Well, I want to make a mention, my lord. Serial number 5, my lord.
5.
Serial number 5. Refer short adjournment, my lord.
I liquid in pagal for the petitioner. The matter being listed for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment to grant further opportunity. Mentioned at the beginning of the day's questioning, seeking adjournment to grant further opportunity, the matter shall be listed for fresh admission in the week commencing 3/8/2024.
Oblige.
13 to 21.
My lord, item 9.
9. Yes, what do you say?
My lord, that for a short adjournment, my lord. On behalf
You
of
are Mr. Agarwal.
No, my lord, I am S. Srichandan. I do not have the power.
So yes, Srichandan on item 9. Srichandan on behalf of Ramdas Achari for the petitioner. The efforts of the petitioner to adjourn the matter continues, starting with 8/4/2026, thereafter on 29/4/2026. Today, the matter being listed for fresh admission, adjournment is sought for on behalf of the learned counsel for the petitioner by the learned proxy counsel. At the beginning of the day's proceeding, to grant further opportunity, the matter shall be listed for fresh admission in the week commencing 3/8/2024.
Your Lordship, item 11. Your Lordship, we have the
Kebe. Our time darkar.
na adjournment by me. Amma bagre jo address ta achi.
You need not explain. If you order, then you have to wait. It can't be taken up priority. If you want further time, then simply I will give you a date.
Item 4, my lord.
These things have to be filed in a memo or affidavit. Is appreciated. This is not the court's duty to search for the address. You may have difficulty in getting the address. That's another thing. Genuine difficult. Yes, Mr. Singh.
My lord, item 4. I may be
4.
My lord.
4.
I am not in a condition.
Efforts of the learned counsel for the petitioner to adjourn the matter on every occasion continues, as it has been on 1/5/2024, 12/5/2024, 20/5/2024. The matter has been heard at length, noting the facts as well as the propositions of law as noted in order dated 1/5/2024, 12/5/2024, and 20/5/2024. Though there is no apparent reason to grant further adjournment. Adjournment is granted reluctantly to give further opportunity to the petitioner. The matter shall be listed for fresh admission in the week commencing 27/7/2024. Yes, next.
Your Lordship, item number 27.
Please wait.
Page 3.
13 to 21.
13 to 21.
Item 16.
16. Mr. Subhasis Mahapatra for the petitioner.
Which time?
Efforts of the learned counsel for the petitioner to adjourn the matter whenever it is listed continues, as it has been on 17/3/2024 and 22/4/2024. Today, the matter being listed for orders is mentioned at the beginning of the day's proceeding. Seeking to adjourn the matter to grant further opportunity, the matter shall be listed for orders in the week commencing 27/7/2024.
Okay. 19 May. Item 19 May. Case notice will be issued.
Time nebe discovery point.
Yes, Lordship.
Like Ms. Mishra was submitting that
Case
now it is the
notice-
prerogative. Court will find out the address. That's not the situation. It is for you to find out the address or not to find out the address.
Case notice may be issued, ma'am.
Fresh notice in what address? Same address se 5 thora notice daware kon achi?
ଜାଣିକି ନଉନି
Ki jani ki nowni court?
ନା ସେ ଅଦର ସାଇଡ
Ki tanar case korchandi?
ଜେନେରାଲ କେସ୍ ହେଇଛି
Kiye downi kiye dowchi kiye nowni seta kahibe na jani ki nowni jo kohchandi kiye dowchi?
ପୋଷ୍ଟାଲ
Katanar kya case korchandi? You are a lawyer. You are paid for your speech. You have to be measured in your words.
ସେଇ address
Jani ki nowni. Are kiye
Sei
dowchi
address
kiye
ରେ
nowni?
ଆଉ
Eta ame court kon kariyo. Suppose let us say that what you are saying is correct also. जाने की से नौनी दौची के
सेम एड्रेस से केस करछन
आज्ञा सेम एड्रेस से केस कले अछि कि सफिशिएंट प्रोविजन आउ हबनी बोली से एड्रेस सफिशिएंट हबो कोन आज्ञा
फ्रेश नोट
सेम एड्रेस से हेले सफिशिएंट ऑलवेज हबो
फ्रेश नोट
अरे फ्रेश नोटिस सेम एड्रेस से देले केमती हबो ना बुझी पर ना आपण के समय नष्ट करंतु से आपण जदी रही बेनी आपण टाइम नियंतु फ्रेश एड्रेस आनंतु ता करंतु से नौनी के दौनी सेम एड्रेस से केस हेची एटा कोन माने इज इट रेलेवेंट टू रिकॉर्ड शैल आई रिकॉर्ड ऑल दिस थिंग्स
स्पेशल मैसेज
then why should people pay us for speaking आपण जदी प्रोविजन अछि सेम एड्रेस न नेले सफिशिएंट हेजो सेटा साइड करी
स्पेशल मैसेंजर नोट
स्पेशल मैसेंजर कोठ आसीओ आपण दस्ती नहीं परिबे दस्ती नेले तापर आपण रिलक्टेंट आपण लोकल काउंसिल थ्रू दस्ती देबे आपण से लोअर कोर्ट रे कोठे अपियर करचंती चेक करचंती को प्रोसीडिंग रे अपियर करचंती that should have been your first strategy rather than saying that say address नौनी से सब जिंस न कहि थाते आगा सो एंड सो कोर्ट से अपियर करची नोटिस देब that is the simplest way to do it इते कोन स्टे हिची ना कोन हिची
नो स्टे मेंटेनेंस मेगर अमाउंट अलाउ हिट
आपण एनहांसमेंट में करते
यस यस मैम
आपण एग्जीक्यूशन फाइल करना आंती
यस
एग्जीक्यूशन फाइल कले कोन हबो
अटैच
अटैच हबो एग्जीक्यूशन फाइल कले न आसिले बीडब्ल्यू हबो एनपीडब्ल्यू हबो कि एठी एटा करी हबनी थारे बीडब्ल्यू हेले एनपीडब्ल्यू हेले आपण नोटिस सेठी देई परिबे देयर आर सो मेनी वेज yes sir next today order टका हबो
Yes.
19 order टका then at 22 to 28
serial number माला 28 माला
Item 22,
28
22 yes
the filing booklet now.
hmm
The filing appearing,
other side पे
I guess, yes, sir.
सेटा टिके ऑर्डर टा कियो पड़िबो आपण मेंशन करियो कोन आपण व्यस्त अछंती then wait प्ला next 23 to 28
माला serial number 28 माला
yes
refer short adjournment
आपण अपोजिट पार्ट ना पिटिशनर
petition माला
अरे एटा ऑर्डर्स पे आसी सफिशिएंसी ऑफ नोटिस पे आपण तो अर्जन केन करछंती देखु नांती कि किछि
नो वन रिकॉर्ड
आ सेटा कोन सेटा रेकॉर्ड होबो ना नॉन अपेरेंस रेकॉर्ड होबो ना कोन ऑर्डर हैज टू बी पास्ड आपण को रहिबे नि आपर माने अन्य कोर्ट रे केस अछि ना कोन
आगे
सेटा कहिबे एटा डेट कर दियंतु
वो कौन सी 17 है
ना ऑर्डर से अछि 17 आठ को पठिए लागि
Red notice.
कोटा नोटिस सफिशिएंट हिच नोटिस जीवन कोन अभी
3 yard.
10 आठ करो 3 आठ 10 आठ मिस्टर पाबो
10.
10
Your Lordship, item number 27, I had filed the requisite, Your Lordship. However, the pin code that I had mentioned on the
did I orders rate out of turn city mention करो फिर if I start taking orders matter out of turn तल complete तो होबनी ना लिस्ट ऑफ है you have to wait आपनकर what's your name
Chetna Prakash.
पिन कोड देबे ना देबे नी
Your Lordship, I just have to file the fresh requisite because
फ्रेश रिक्विजिट नो आपनकर एनवेलप रे पिन कोड लिखिबे
yes, Your Lordship.
सेटा फ्रेश काहे की तो नष्ट काहे करचंती why you are wasting your requisites and paper how do you know the pin code वेबसाइट को जिबे इंडिया पोस्ट रा you will get the pin code
Yes.
एटा डेट करंतु केबे 27 टा
वो कौन सी 10 है
but order needs to be passed mention rate hi paribo yes item 29 to 33
Item 30.
30
I was informed, this is a matter that election matter, OC election matters. So I was informed by somebody that the PIL is also pending for the Honorable Chief Justice Court. Notice has been issued and the matter is probably coming on 15. So I inform Mr. BCCI's counsel, Mr. Ratta. She also.
I'm also there, Your Lordships, online.
I mean, you are saying the subject matter is same or similar.
So we were only, I was
Same,
saying,
Your Lordships.
Such is the same issue before the division.
same, exactly, election.
And it was mentioned yesterday, it seems it is coming up on 15th also.
15th of July.
Next month,
Next week.
next week.
So as well, if it can be,
Tag agent hearing agent let it be
Say bench nahi pari.
place.
Moon yes,
No, upon the place.
place.
Not that, this is place kar diante pada.
It's a
Again,
serious conversation. There has to be some.
no, yes, I understand. I understand, Maharaj. Yeah, if your lordship would say that,
20 week राशि होता है कुछ 20 7 है ना 3 8
no, if this could be tag, your lordship may place or we will mention there for tagging.
obvious. Either motion bench, that is the motion bench, and PIL bench is the same bench.
Or
This
or you can lordship may take cognizance of our mentioning.
what I can do that without it simply can be adjourned so that tagging will be easier. And whenever you require this to be mentioned, you can only mention if a date is given. So simply it may be adjourned so that it becomes easier for you. The issue of the listing of the matter will not be there. And if you want to this matter to be listed, make a
Yeah, lordship may simply adjourn it.
Okay.
I was thinking then we can can be mentioned in
without
that.
any orders. Taku rokhidiyo, hala?
Upon Rockidale, then I can.
You have to move the motion bench.
I have
or PIL
to,
bench.
I can move in the Monday bench. Motion bench is a Monday. There's a motion bench in Monday, subject to my learned friend agreeing. We can move the Monday bench for listing before the Honorable Chief Justice.
Lordships.
That
I have
can
no
be done.
problem.
Monday bench can be moved.
It is release great.
Really? How many? Just
Hey,
simple.
no, in the sense, the registry को नॉगल है, से file टा place
हाँ,
करिए ठीक. If you want listing, I mean,
No,
you can
ठीक है.
simply file a memo.
हमें खाली भावते हुए कि गोटे अगर यदि hearing
Yes, yes.
चलती same issue decided, let it be decided.
It has to be. It has to be
For-
that way only. Yes.
See.
Basic 34 to 40.
Item 31, my lord. My friend, one big time.
For admission posting करो तो आपण कहाँ पे?
My lord, on behalf of Mrs. Soma Patnaik, she is inconvenient to be here.
Other side, Venugopal.
My lord,
आपण other side पे?
no.
31 रे आपण अछंती. ठीक है, just give her. Problem, madam, is that at 4:30 they are coming and saying that they were not informed. Please inform. Like yesterday, we continued till almost 4:45. So they wait for you.
My lord.
No difficult in giving a date, but you have to inform the other side.
Yes, my lord. I'm informed କରିଛୁ.
କରିଛନ୍ତି?
Yes, ma'am.
ସେଟା କହୁନାହାନ୍ତି ମୁଁ ପଚାରୁଛି କିଏ ଗୋକିଲ କଣ?
Sorry, ma'am.
No. ଆରେ why would be apologetic? Then କଥାବାର୍ତ୍ତା ହବାନି ତାହେଲେ ସବୁ କଥା ସରି କରିବୁ ମୁଁ କଣ କରିବି? ଡେଟ୍ କରନ୍ତୁ.
Who comes in 17
17/8 week ଆସିବ.
God bless, ma'am.
Item 36.
My lord,
Just one second.
item 30.
Yes.
32, my lord.
32.
Instruction, my lord.
ମାନେ no instruction.
No instruction.
କଣ କରିବା ତାହେଲେ? Disposed of. ତାହେଲେ memo ଦିଅ.
Memo.
14 ବର୍ଷ ହେଇଗଲା ନାଇଁ କି?
My lord, item 40.
ରାମ ଫେରିଲେ.
My lord, item 40.
ଗୋଟେ ସେକେଣ୍ଡ.
I
ଆପଣଙ୍କ
have
ନାଁ?
appeared for OP 1 and 2.
ଟିକେ ଗୋଟେ 32 ରେ କେମିତି 40 ନେବି? ମୋ ପାଇଁ possible ନୁହଁ. 32 ରେ your name sir?
SR Behra, my lord.
On behalf
On
of
behalf-
DK Pradhan.
Shamsi Kumar.
Never mention, you can't appear for a senior advocate. SR Behra on behalf of DK Pradhan na SK Raut. No one is
No
now.
one is there.
DK Pradhan लिखित होची. ने बिल्कुल के माने कांटेक्ट टच रे भी नाहंदी DK Pradhan और SK Raut. माने लॉर्डेड काउंसिल दे आर अपीयरिंग हियर. ओके. ठीक है. मेमोटा रखो. 32.
Item 36.
Just one second. मैडम कौन कहते को मैटर?
Oh, item 40, my lord. Appeared for 1 and 2 OP. Counted
Mr. Swai is there. Mr. Swai कौन?
I am for the petition.
डेट चाहूँ यही परियो?
Yes.
डेट कर दियंतु.
Who comes in 17
17 ये week करो
Counter update दो.
इंट्री ऑर्डर में
Simply, इतना कोई adjournment order थिला ना stay order थिला
adjournment order stay order भी होते हैं सर
stay थिला it is argument on us that's why disturb करछु
stay order
adjournment date has to be fixed यदि आपन adjournment date थिबो like the matter shall be adjourned to so and so week then there has to be stay order so we continue
obliged.
Item 36.
now until further orders Mr. Swain
Yes, ma'am.
you are not expected to be not looking at orders
Sorry.
no why again sorry
Yes, yes, that's it.
it is until further orders such
Yes.
I just checked
Obliged.
17
Item 36. 122.
36
6.
mediation ହେଇଗଲା ମେମୋଟା ଆପଣଙ୍କ ନାଁ
Silas Patra.
ଶୈଳେଶ ପାତ୍ର ଅଦର ସାଇଡ୍ ସେ ଅଦର ସାଇଡ୍ ଇନଫର୍ମ କରିଦିଅନ୍ତୁ
Sir,
I think
inform
Mrs. D Sahoo from Chamber of Amitpur
Se kar ଦେଇଛନ୍ତି ଆପଣ.
କାହା ନାଁ ଲେଖିବା ତାହେଲେ ଅଦର ସାଇଡ୍ କାହାକୁ କହିଥିଲେ can you remember
Ma'am.
ଦେବଦୀପ୍ତ ସାହୁ ବୋଧେ ମ୍ୟାଡାମ ଯୋଉ କହିଲେ ଠିକ ଅଛି yes you are mentioning
No, my lord, item 1.
Pardon, concern my lord. My lord, in item 31 रे interim order टा था interim.
ଏଥିମାନେ adjournment order ଅଛି କି adjournment ହେଲେ date ଥିଲେ ସେଟାକୁ adjourn କରିବାକୁ ଆଉ ଗୋଟେ date fix କରିବାକୁ ପଡିବ
हाँ,
ଯଦି stay order
date पे दे children's. Item
ଆପଣ
30.
ନିଜେ ଦେଖିବେ ନା ସେଇଟା ଯୋଉ ପେପରଲେସ୍ ଦିଆହେଇଛି ତାକୁ ଦେଖିବେ that is for you only ଆପଣ ଦେଖିବେ ସେଟା କଣ order ହେଇଛି କହିବେ interim order date କେବେ କହିପାରିବେ
Oh my lord.
next date of hearing ଅଛି କିଛି ଅସୁବିଧା ନାହିଁ interim order passed earlier sir continue till the next date of hearing ଏଟା order କିଛି ହଉନି କମ୍ପ୍ୟୁଟରରେ ଏଟା ପୋଷ୍ଟିଂ କରା ହଉଛି to save time ହେଲା
Item 1.
Item 1.
yes
On behalf of my learned senior, Sri S.K. Samantarai, is out of town because of some medical urgency. And we have not.
Just a minute, Mr. Bucha, just a minute. What happening in this case? The railway is the appellant. We are the appellant in this case. My lord, I remember this reference part is concerned. My lord suggested to government should come with a proposal for. Yes. That is already I have suggested is under consideration of the secretary law is monitoring all this issue. But it is a long-standing issue. So what I am requesting my lord, lordship may hear it on merits and dispose because the appeal was filed by us. We have prepared the appeal. It is a burden of the state government also for interest all this part. If you want to settle, then we can, as per the orders of my lord, we can dispose of and it can be. Any date may be fixed.
in fact since last week I have whenever the request is made for hearing I have no more listing the matter I'm simply sending for hearing list in case of state also but since there is an effort of it has been taken up by the Hon'Ble Apex Court also then that should be a policy in
Yes.
in general not regarding case specific
No, what I heard from the Apex Court also seriously
let the
thinking about
policy
this.
be in place so that whether this case will be disposed of or not that's not important
Not it is a different issue, yes.
Policy in
But
general.
this is required a policy, yes. A lot of cases are like this.
Let it go for let it go to the regular course of hearing. Mr. Ponda.
Madam.
I'm sub item 1. I'm for sub item.
Or lordship may fix any date for hearing, then we concluded.
L88 2624. The matter is listed under the heading for referral to special mediation drive 2.0 - mediation for the nation. Stop. Yes, please. Please carry on.
Let central government, so council of both sides sit together and
Mediation.
mediation.
ବସୁନାହାନ୍ତି?
Not in mediation center.
Problem ହଉଛି
Not in mediation center.
Try to understand. We can't do anything. That's why my lord is suggesting.
actually You are welcome to always take steps for mediation.
Aman.
But upon the list hochi, then an order has to be passed. Can a court direct you for a kati bosundu tapare have some food and then go elevate your mood, then agree for a settlement. Upon jaha kariya katha karantu. Whenever you agree, please list it for a mediation. Sange sange listing out. Policy no hale to upon. Mr. DK Padi, senior advocate, DSGI, along with Mr.
All three cases different counsel are pass on a slip minor. First case Samantara, second case Mr. Abhishek Mohanty, third case is
Sleep
Harichandra.
along with so and so, hela. Mr. MK Ponda. Sir Ponda likha tha ka Niranjan Ponda. So Niranjan Ponda along with Mr. MK Ponda for the opposite parties. 1 and 2. 1, comma,
Bottom
kh kh. Apna ABCD kale haboni ki? Odia re kon k kh jaha ki likhibe. Opposite parties 1 k kh
Not 27.
Hopper won't be good. War spelling lecture even. Go. 2 by K.
27.
Two by upon appear question than a Satyavama Raut.
I am appealing first item or the last item. 3 meters
appear to the system Pocharuchi. Upon you cast a last item, Protomare Koru, Cox, Go Gala. Tapare 2 को 2 कहबे कि 2 कहबे पर 2 लेक्चर दे 2 पाई के सत्यभामा ना पर देख पर ना
देखो
2 भी लिखो डाउट रचो 2 लिखिता OP3 मिस्टर DL लेंका जी दा आर हो रेस्पोंडेंट appellant हेले मिस्टर DSJ अलग से ना लिखि देबे तापरे 1 क ख ग पूरा लिखिबे हो जाए and 2 Mr. MK Ponda R3 हो चोती Mr. DL लेंका including today the matter has been listed earlier on 21/4/26 23/26 on all these dates the matter has been listed under the heading for referral to the special mediation drive 2.0 dash mediation for the nation. It is submitted that by the learned DSGI, learned senior counsel, DSGI, that he has intimated the authorities to have a policy regarding to have a litigation policy for arriving at a mediated settlement in land acquisition cases. So, it is submitted that unless a policy is finalized, the learned counsel, the department cannot proceed with a mediated settlement. Stop. Accordingly, the matter shall be listed for hearing in its usual priority for the year 2024. Or it like the appeal being of the year 2024. Mr. MK Ponda, learned counsel for the respondent 1 and 2 submits that there can still be a possibility of a mediated settlement. Is directed, even though the matter is it is observed, even though the matter is directed to be listed for hearing, the learned counsel shall have the liberty to pursue to arrive at a mediated settlement acceptable to all the parties. Because you will see that in Samadhan also LA is included.
So one more flat appeal memo is solved on us. Appeal memo not
finally
notice on limitation limitation delay by control. Thereafter matter is admitted.
Admitted. LCR call for each.
LCR
तो लिखिए जोटा लिखले नहीं कि mediation settlement तापर लिखिए जो listing पे लिखले पर hearing लिखो तो ता पूर्वरु the appeal is admitted
Already
in view of कुछ ता date टे कहले को पाई notice 12 right
19/1/2000.
ठीक अछि the appeal having been admitted, appeal memo along with the connected papers shall be served on the learned counsel for the R1, 2 and 3
Respondents.
ହେଲା बड़ा बहुत हुआ जाए चली गले गोटे कॉपी हला हो तो one copy on
Sub item 1.
just 1 second. The appellant as well as the respondent shall have the liberty to receive the copies of the scanned copy of the LCR from the registry as per rules. What LCR टा copy चाहिए देखिए नहीं पेन ड्राइव रे नहीं
मतलब sub item 3.
just 1 second गोटे पर गोटे जीव आपण को आपण माने then LAA 27 ये अछंती आपण रेस्पोंडेंट पे सर
I am respondent for LA 27 of 2024.
सीबीसी एडमिट हिची
हाँ, admit is same.
कॉपी रे आपण कॉपी पाई छी
Copy no say.
फाइनेंस तल सेम ऑर्डर
We are the appellant. We have filed this. It was already admitted.
In the third case,
LAA 27 of 2024 appellant समान रहला R1 हेले मिस्टर करुणाकर रथ R2 मिस्टर डीएन लेंका हिची सॉल्व कर दे मिस्टर गुंचायत
My lords.
sub item last 30 of 2024.
हां
All will same. Only respondent number, only respondent one thing.
इते क ख ग घ म नहीं
Very respondent.
सेम appellant सेम रहले से नाटा देबे आपनकर जो सीजीसी को नाटा देबे आपण R1 को भाई
The Harichandan is appearing along.
के पंडा R1 Mr. DN Lenka execution. Absolutely. Sir, copy on the learned AG also.
Yes.
And you take the lower court record from the registry, scanned copy.
Yes. On pen drive.
Yes, next. Which pen? Rita, right, hearing this should you know? I'm joining here. Hearing list of 24 add appeal का तो October. Liberty to mention लिख देता हूँ सर. Whenever they require liberty to mention. Liberty to mention for listing with line add.
Item 2.
Ashok Kumar Behra for the petitioner.
Item 2, I file memo for adjournment to time. Item 2, I file memo for 2 time adjournment.
Mr. Ashok Kumar Behra for the petitioner. The efforts of the petitioner to adjourn the matter since on 6 as it was earlier on 16/4/2026, 4/5/2026 and 11/5/2026 continues. The matter is kept pending since it was presented on printed on 28/2/2025. Today, memo of date is filed seeking adjournment to grant further opportunity. The matter shall be listed for fresh admission in the week commencing. The memo shall be taken on record. Can copy be updated? To listed it. Commencing 3 years.
Item 3.
Mr. Mahapatra Day.
Mr. Day.
Mr. K.
Kaushik Day.
Kaushik Day for the petitioner. Yes.
In item number 3, Your Lordship.
Yes, please.
In this petition, we have challenged the orders passed by the Learned Family Court, wherein in the execution petition filed by the opposite party wife under section 125 subsection 3, the Learned Family Court has enforced the claims for area maintenance beyond the period of 1 year, which is in the teeth of first proviso to section 125 subsection 3. To give you the
have you read any case law on this?
Yes, Your Lordship. Even I'm relying
which case law?
Even I'm relying a case law of this honorable court, a coordinate.
Apart from this court being honorable, there are other honorable higher courts.
Yes, Your Lordship.
Which court?
The Honorable Supreme Court in this.
Obviously.
Yes, Your Lordship.
So have you read the decision direct on what you are arguing?
Yes, Your Lordship. What?
Which paragraph?
The
Which decision, which paragraph, what you are arguing has been settled?
stating, Your Lordship, that is Shant. That is Pungadi and another was.
Require preparation, Mr. De.
No,
you
Your
are
Lordship.
completely off track. The point you have raised regarding 125(1) proviso has been answered by the Honorable Apex Court.
Yes, Your Lordship.
Which decision?
Shanta and Usha Devi, Shanta at the rate Usha Devi and another versus BG. Shanta at Usha Devi and another.
Elias, not at. Elias?
Elias, Usha Devi and another versus BG Sivanajapa and
BG.
BG. The citation is 2005 4 SCC 468. This was a judgment that was relied by the
Completely off track, Mr. De.
Supreme
Court, unless you read, you can't submit. How is it that I am more prepared than you?
Your Lordship.
The point you are arguing, at least it is maybe overruled. I don't know.
No, Your Lordship.
You know the decision on this?
Yes, they are saying that there is no such requirement for filing successive application.
Sir, don't give a speech. Which is the decision on this, the point you are arguing regarding applicability of 125 that's been discussed at length by the Apex Court.
This was a judgment which was relied upon by the learned family court, and based on which my maintainability application was
After that, there has been some other decision. You are distinguishing Santa, which was relied on by the Apex, by the trial court, the family court.
Yes, Your Lordship. What I am stating is that
did you make that argument before the trial court?
Yes, Your Lordship. We have filed a maintainability application that was rejected. That's why.
Regarding Santa, did you argue that? Has it been noted?
Yes, Your Lordship. If Your Lordship, if Your Lordship comes at page number 43 of the first RPFM.
Not RPFM, the judgment where it has dealt with your submission.
I'm placing upon that, Your Lordship.
Which page? You are saying
page number 43, Your Lordship.
43, internal page?
Yes, Your Lordship.
43?
Yes, Your Lordship. At para 3, I have heard both the sides on the petition. Although no written objection on the petition has been filed from the side of the petitioner, learned amicus curiae for the petitioner vehemently challenged the said petition of the OP orally during the course of the hearing by citing the decision of the Honorable Supreme Court in the case of Shanta, alias Usha Devi and another versus BG Sivanajapa, reported in 2005 4 SCC 468 for her contention that insisting on filing of successive application is unreasonable since liability to pay maintenance is a continuing liability and the bar under section 125 subsection 3 of CRPC first proviso is not applicable in the present case. Being similar to the facts and circumstances of the said case as decided by the Honorable Apex Court. During the course of the hearing, learned amicus curiae for the OP relying on the decision cited from his side argued that the petitioner can only claim for maintenance of preceding 12 months, whereas the present petitioner having filed the petition on 25/9/2019 has claimed for realization of arrear maintenance for the period from 14/11/2018 to 14/6/2025. Although she is entitled to only 24,000 for 3 months only.
So, do you have any contrary view to Santa and this Usha Devi?
I'm relying on a paragraph.
Sada Khatun.
I'm relying on a coordinate bench decision of this Honorable Court, Your Lordship.
Supreme Court?
No, they're not.
So, please appreciate that you are trying to distinguish Santa and Sada Khatun, which are Supreme Court decisions.
What I'm trying to impress upon Your Lordship is that.
Don't impress me. I'm not going to be impressed to overrule a Supreme Court decision. Anyway, let us not spend time like this. CRPC achi?
Yes, Your Lordship.
Mr. Kaushik Dev for the petitioner, opposite party blank. The learned counsel for the petitioner is heard at some length.
May I make one just submission, Your Lordship?
Let us not spend time like this, Mr. Daude. You will be going on saying that you want to distinguish Supreme Court decision. by coordinate bench decision of this court, which I cannot do.
Your Lordship,
Then you do not know what is the decision on this point by pronounced by Supreme Court. Latter decision also.
Your Lordship, what the opposite party has done is, initially the execution petition was filed only for 3 months.
Your point, if you presume that I am unable to follow your point, you have to tell that. Repeating it doesn't help. You are saying that beyond 1 year it could not have been granted.
What they have done is that without filing even an amendment petition.
Can you not listen because by speaking you cannot understand? Is it not your point that the court has granted maintenance areas of more than 1 year?
Yes, Your Lordship.
So that's the point I have understood. Correct. So you did not repeat that point 3-4 times again.
Your Lordship, my proposition was here that even without moving even an amendment to that effect, they have only provided a memo of calculation, and in that regard, the court has taken that into consideration.
Which provision they have to provide the amendment?
Your Lordship,
once there is a direction of the court, and you do not deny that you have not paid. Amendment, which provision? In CRPC, by which provision amendment is to be brought?
The problem would be in that case that they would be exceeding the pleadings of the parties, Your Lordship. That's what I'm.
That is your figment of imagination. Imagination doesn't help in litigation. This kind of figment of imagination that unless if you are disputing the calculation, you have every right to dispute the calculation. You are not disputing the calculation, but you are saying though calculation is correct, that should be by way of a amendment. That is your figment of imagination. Court cannot go by imagination. Did you take a stand? Did you dispute the amount of calculation by filing any pleading?
No.
Did not. That is how it doesn't work. Yes, 125.
The first proviso to subsection 125.
Yes.
Subsection 3 of 125.
So now you are satisfied, or you will say again that I may be heard for a minute?
No,
so the problem is I allow you. Basically, if you ask me, I always appreciate your efforts, and rather I'm enjoying the conversation. But the problem is that after you speak for half an hour, then I ask you these 2 questions, the entire case is gone. That is the difficulty.
So this were my.
It is not like this that I am preventing you, but I have to manage the time also.
I bow down.
In the second matter, you are arguing, and when ultimately I will ask you this question. After say you argue till 12:30. At 12:30 sharp, I will ask you this question. Did you dispute the calculation? Did you file any pleadings? Do you know the latest decision on this which governs the field? These 3 questions I will ask at 12:30 also. So there it becomes a problematic issue because after spending half an hour or 40 minutes, both of us are on a road to nowhere. I still have to adjourn the matter. And regarding appreciating the point, I have my speed. Whether you like it or not, I have understood the point. Because you are so precise, I want to encourage you that. Because you said that beyond one year, we could not have been claimed. That's the point. It is not a money claim, Mr. It is not a money suit. Please appreciate. This is a direction by the court. What you have done, you have started arguing a money suit, barred by limitation. You must have thought that why 125 doesn't contemplate so. Even if it contemplates, why it has been interpreted by this Santa and Khatun.
Yes.
Now the other point is most daring. I am not that daring that I will distinguish 2 Supreme Court decisions and the latest decision where the Supreme Court has circulated throughout India, stating that 141, 142, this will be circulated everywhere. And obviously we are receiving them. I mean, High Court is receiving those judgments also. Though, because you see, you have to cite at the bar. We did not learn the law exactly in that way because you have to educate us. Then why the Supreme Court is taking those steps? It has to be circulated to every court, every family court. But keep up your efforts. You should have this spirit of arguing, preparing, and whatever way you are like, you argue. But because of the time constraint, I have to cut you some. These are at some length. The petitioner before this court is the husband in the marriage. He challenges the judgment passed by the Lord Judge Family Court. That's Roman 2, Bhubaneswar. You are challenging execution of the original case.
The execution, Your Lordship.
Then you should have, then that's another. I thought that you are challenging the judgment.
Actually, we are challenging the 3 orders passed during the execution
In
petition.
the prayer or the.
There are 2 petitions. In the first, we are challenging,
Order dated 10/11/2025.
wherein my maintainability was.
RPFM my understanding is that unless there is a final order passed against the interim order, writ petition will lie. That is the starting point, what I understand. Subject to you enriching or. I don't think revision can be of a interim order. ସେମାନେ କିଛି defect ଦେଖେଇନାହାନ୍ତି?
No.
ଫେସ୍ staff report ହେଇଛି. Then there will be difficulty. The petitioner, husband in the marriage, he challenges the order stated 3/7/2025, 31/3/2021.
And 10/11/2025, Your Lordship.
10/11 तो नहीं था जी, page 24 देखो तो. You are having your brief.
Yes, Your Lordship.
Look at page 24, prayer, paragraph caption. You should better keep your phone below so that it doesn't fall off and आराम से be comfortable.
My Lord, it is at page number 17.
Prayer.
The petitioner therefore most respectfully prays that this honorable court may graciously be pleased to admit the revision petition for hearing, issue notice to the opposite party, and after hearing the parties, be pleased to set aside the impugned order dated 10/11/2025, passed by the learned judge, Family Court number 2.
It's not matching with my brief.
My Lord, there must be 2 RPFM.
RPFM 30.
30. Yes, Your Lordship.
I'm holding 30.
Yes, Your Lordship.
Doesn't match. Achha, no. I have opened 272. Correct.
That is the previous.
30 lekho. 30 lekho. Call lekho. 10/11/25. Passed by the Lord Judge Family Court. Passing Roman 2, Bhubaneswar in criminal execution number 21/2019. Arising out of CRP case number 52/2016. With a further prayer to allow the petitioner's application dated 17/9/2025. Now take to the page where the 10/11/25 order ta achi.
Lordship, that is it. Page number 42, Your Lordship, of RPFM 30.
Yes, 30. Now I have opened it correctly. 32.
Page number 42, Your Lordship.
42.
Yes. At the bottom part.
Just one second. I'll get there. The order dated 10/11/2025 is a order made in the interim. in the continuing series of orders, the next order being the next date of posting being 2/12/2025. The matter shall be placed before the Register Judicial for staff reporting to be done again, whether in a pending application against in a pending execution application as indicated above, if the interim order or if one of the order is challenged without the application being disposed of, revision under section 15 section 19 into bracket 4 of the Family Courts Act will be maintainable, or a writ application would lie against such an order. Then RPFM 272.
In RPFM 272, we are challenging two orders. That is the
So the execution is kept pending there.
is pending, is continuing as of
Same
now.
order tale. RPS 272 रे lecture अछि same out heading करिवे. ने cost title लिखिले है ना. Mr. Kaushik दे. Challenges जो order लिखिले ने ऊपर है. सिर्फ लिखिवे. Order dated 3/7/2025 ने आगो हबो 31 मार्च 2021 टा ठीक ना भूल टाइप ही
No, sir. No, your lordship. That is correct.
21 भी ठीक अछि.
Yes.
ताले order dated 31 मार्च 2021
Then
and
third,
3/7/2025 passed in criminal execution number 21 of 2019 arising out of CRP number 52 of 2016. The execution still pending before the learned judge, learned executing judge. Has directed SRB done पूरा sentence का complete ऊपर जाके से थोड़ा से same order होगा. SRB done by किस तरीके होते हैं? 10 by 14. The matter shall be listed on 15.
grateful, your lordship.
But please, when you started reading those two Supreme Court decisions and the High Court decision,
Yes.
you must think that whether High Court can distinguish and take a different view. There are so many on precedents also. There are so many judgments. How High Court will deal with Supreme Court orders. Then also please examine. I'm purposefully not citing the decision and the paragraph because that will be the
I
homework
will.
for you. Please check. 125 has been extensively dealt with by the Apex Court,
Yes.
and they have circulated by noting that this is a law of the land. This is law of the land by Article 141 and 142. Everyone has to follow. Please check it.
Sure. Much obliged.
Item 6.
Asor करते हैं
7.
Janakikanta Mahapatra for the Commissioner. Opposite party black. Yes, Mr. Mahapatra.
My pleasure. Your lordship, the petitioner is seeking transfer from the Bhubaneswar court to Jaspur court. Family judge, Jaspur, your lordship. So on the ground of that, your lordship, now the present petitioner is residing at Jaspur and with two kids, your lordship. One is 3 years and another.
Needs to be carried to the court under which provision?
No.
So why you are making that argument? Even Jajpur also, it is the most convenient for carrying the kid to court.
No.
Kids should not be involved in litigation. They have to be kept in, custody of some of your well-wishers.
They are,
Maybe next door neighbor.
yes. They are studying.
Kid argument टा कहीं की court evolve होइची movie पाउने पड़ता था. With a lot of effort.
Only the your lordship, the taking.
सेटा गोटे आपनकर general speech रे ठीक अछि. ଏଇଟା ଛୁଆ କଣ କରିବେ ବହୁତ ଅସୁବିଧା ଅଛି।
They are studying here.
So ତାଙ୍କ ସାଙ୍ଗରେ କେସ୍ କୁ କଣ ତା ଭିତରେ ଯେହେତୁ ଛୁଆ ଯୋଉଠି ପଢିବେ ତାପରେ ସେଥିପାଇଁ ବର୍ତ୍ତମାନ ଆର୍ଗୁମେଣ୍ଟ ହେଲାଣି ମୁଁ ସମ୍ବଲପୁରରେ ପିଜି କରୁଛି କାଲି ଜଣେ ଆର୍ଗୁମେଣ୍ଟ କଲେ କଟକରେ ପାଠ ପଢୁଛି। ଏଇଟା କୋଉଠୁ ଆସିଲା ଏଇ ଯୋଉ କନସେପ୍ଟ ଆସିଲା ସମ୍ବଲପୁରରେ ପିଜି କରୁଛି କଟକରେ ପାଠ ପଢୁଛି ବେଟର ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ।
Yes, Your Lordship.
We have to be because we are paid for that.
Yes.
ଆଉ କଣ ଆର୍ଗୁମେଣ୍ଟ
And in
ଆଉ
around
ହଜବେଣ୍ଡଙ୍କ ନାଁରେ କେଇଟା କେସ୍ କରିଛନ୍ତି ଆପଣ?
only 125.
498 ଅନ୍ୟ ଗୁଡା କରିନାହାନ୍ତି?
No, no, Your Lordship.
ଠିକ
Your
ଅଛି,
Lordship.
notice ନିଅନ୍ତୁ।
Yes.
Appearance lecture, Mr. Janakikanto Mahapatra for the petitioner, opposite party blank. The petitioner before this court is the wife in the marriage. C6. Transfer of the CP number 96 of 2024 pending before the learned judge family court Bhubaneswar. এখন 2 লিখেছেন কি? 2 বলতে লিখছেন না কোন? আপনারা কোন লিখছেন? হ্যাঁ, family court, learned judge family court Bhubaneswar dash
2.
Roman 2.
Roman 2.
Roman 2 এটি লেখা হয়েছে
Then 4.
কোর্টরে হজুর লিখি দিয়েছেন 2 লিখেছেন Roman 2 to the
Petition.
court of learned judge family court page 8 রে দেখুন
Okay.
page 8 রে নোটিস লেখা হয়েছে to the court of learned judge family court Jashpur it is submitted that ଆପଣଙ୍କର 125 ଟା କୋଉଠି ଫାଇଲ କରିଛନ୍ତି ନା 144 କୋଣ ଫାଇଲ କରିଛନ୍ତି
125 days.
କୋଉଠି
Bhubaneswar. At the time she was residing at Bhubaneswar.
ତ ସେ ଗ୍ରାଉଣ୍ଡ ଟା ନେଇ ହବ
ନାଇଁ ସେଟା Your Lordship's
ଠିକ ଅଛି,
permission.
it is submitted that after the petitioner's marriage has run into rough weather, she stays with her parents at Jajpur, at Malda, in the district of Jajpur. She finds it difficult to attend the matter at Bhubaneswar and hence pays for transfer of the CP. Issue notice to the opposite party along with this order. Stop para requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 or 5.
Within 3 working.
Within 3 working days. Returnable date be fixed to 13/8/2024. The matter shall be listed with, for orders in the week commencing
17
10/8 ଆପଣ କଣ କ୍ୟାଲେଣ୍ଡର ଦେଖୁନାହାନ୍ତି ଆପଣ ଜୁଲାଇ ଦେଖୁଛନ୍ତି ମୁଁ ବି ଜୁଲାଇ ଦେଖି ଡାକିଛି ଜୁଲାଇରେ 13 ଅଛି 13 20 27 ଅଗଷ୍ଟରେ 3 10 17 24 କଣ ଲେଖି ଡାକିଲେ 10/8/2024 listed in the week commencing 17/8 ଆପଣ 17/8 କହିଲେ ତ 17/8/2024 yes
Oh, please.
item ଏଇ
ନେକ୍ସଟ ଡେଟ୍ କେବେ ଅଛି ମିଷ୍ଟର ମହାପାତ୍ର ଜାଣିନାହାନ୍ତି ସେଟା ସେଥିପାଇଁ ଆଇଏ କରିନାହାନ୍ତି ସେଇଟା ପଚାରିବେ ନା these two informations are very much necessary
ସେଟା
ଆପଣ ତ ଗୋଟେ କେସ୍ ଭୁବନେଶ୍ୱର ଆଚ୍ଛା ସେଟା କଲେ ଫେର ଭୁବନେଶ୍ୱରରେ ଅସୁବିଧା ହବ ଆପଣଙ୍କୁ ଠିକ ଅଛି
I'm not
there
submitting.
are so many aspects
Your
anyway
Lordship,
I was just trying to
I'm
understand.
sorry to say, Your Lordship, I'm not placing before Your Lordship for further proceeding because I have not filed the IR. I mean,
No, I understand, but why you have not filed? I was trying to think those lines. Liberty to mention.
Oh, please.
Mr. S.S. Das, senior advocate, along with Mrs. Modi for the petitioner. The memo of appearance of the learned senior advocate shall be taken on record, scan copy be updated. Yes.
Well, it's an application for transfer of a matter. Divorce matter pending before the learned senior civil judge Sunnuapara Malat. Well, admittedly, from the plaintiff itself, I'm saying Malat, I'm not setting anything from out of the country for Malat. Admittedly, the marriage was in suburban. And admittedly, in the plain, the last resided at Malat, Hyderabad. Admittedly, the wife is residing at Delhi and also commutes to Bhubaneswar, my lord. In this scenario, my lord, the case was admitted in Noapada. And one more important starting feature is that only notice was issued. It has never come to me, my lord. Then immediately thereafter, Order 5, Road 20 order was passed. By coming to know about it, we appeared there, my lord. But the fact remains that cause of action at no point of time arises in Noapada. And secondly, another important aspect, my lord, the husband staying in Hyderabad. But from Hyderabad to Noapada, there is no direct connectivity. And the wife stays in either working in Delhi and comes to Bhubaneswar to her parental house. So what I feel, the case be transferred from Noapada to Bhubaneswar to be convenient for both parties. And Lordship knows that 2020.
No, what is your state? The MAT case is about section 9 or section 13?
13.
13 filed by husband. So you want to continue with the matrimony, or you are also agreeing for a separation?
I think
you want to part ways peacefully.
No, what I humbly pray, my lord. Once the notice is issued, then the
No,
matter.
definitely.
No, I would say I had spoken to the girl.
Yes, you talked to them.
I have spoken to the girl.
So that was the imperative in my speaking.
Well, exactly. Well, I have
talked to them and let them not let this not be opportunity.
Exactly.
For amicable settlement.
Yeah,
let this be opportunity.
Yes, now the father of the girl wants that there has to be a settlement. Well, it has not been blown, in fact, to a stage where settlement could not be done. But there is some kind
possibly, there will be gap in understanding and so many factors crowded and
yes. But if she notice is issued, then here in the mediation probably it could be done.
High learned senior advocate for the petitioner. The petitioner before this court is the wife in the marriage. The C6 transfer of the CP number. You can take your seat. I'll just complete the order. You have your seat. I'll complete the order.
Sorry. The number is MAT case number 47.
This is a guardianship. Oh, I don't know what is that. So I have opened another ERPC 156 Kavita Parik versus Rajendra Parik.
This is Rajanandini Pujari.
Serial number?
8.
8, I'm sorry. In fact, I have thrice opened and I have tried all the 3 times wrong files. This is the little difficulty in virtual handling of files. They have a difficulty in typing it elsewhere. Initially, when everything was tried to be done virtually, so especially the senior secretaries, they miss the serial number, so they don't look at the brief and they start typing.
Yes.
Not here in chamber. Finally, when they are preparing, so this is happening also.
Well, I'll just take half a minute of your slot.
Yes.
You also knows earlier, about 10 to 15 years back, that voice recording app was loaded.
Yes.
And instead of having a stenographer or some of
Dragon software.
Yes. Well, what happened? When I dictate something, after I see the output is different. So I stopped it.
Even still, we are experimenting. We have got Adalat AI and Dragon to a certain extent.
Yes.
But I find that maybe due to web speed or what, it is not responding.
They're not.
I have tried that. So it is not at times because the software is not here.
Yes.
It is somewhere in the cloud or in some database. Whatever you are dictating, it is recording and converting. That way, I find that this Google and Samsung virtual keyboard is better. They respond immediately.
Yes.
But how to use that in a large scale? So that is not. Apna छोटा voice message पठौଛନ୍ତି phone रे ठीक अछि. ते फटकी recording हे जाउछि. But conversion in the large scale, perhaps, they don't make it free. Why they will make it free? Now everything is charged.
Yes.
Gmail, what?
Sir, Supreme Court last week judgment say collateral judgment, AI generated judgment, and Supreme Court has come out very heavy on them.
Yeah, I've been attending a lot of conferences on this AI. How it will assist?
No, it will not assist us, in no way.
but it is evolving. We do not know.
Well,
My understanding is AI is struggling to catch up with NI. It is always a struggle for AI.
Well, shall I say one thing?
NI, yes, please.
Well, first of all, initially it was an analog system. Analog system got digitized. That is, what is there in analog, we can store it in the digitized system.
Yes.
Then it becomes AI when I make others to have an access to my digitized system. That is digitalization. When my digitized version gets digitalized, then it goes to the cloud. Then somebody else can have access to that. Well, this is the entire AI manner, working. Now, supposing, say for example, law has to bend before justice. That is 1993 volume 4 supplementary SCC 595. It's in my memory mallet. But while supposing I want my digitized most to be digitalized, there is a typing error. Then that gets circulated. If the court, while delivering judgments, takes note of that, there's a mistake.
In fact, there is one discussion that how the AI is hallucinating. The problem is that it's a large language model.
Exactly.
AI is reading. So today, NLUO, Madhusudan Law College, they have their moot court problems. The AI has read it. But it cannot distinguish whether it is actually a Supreme Court judgment or a High Court judgment or a moot court problem.
Yes.
Because the source of hallucination is very interesting.
Well, that is the
large language
absolute
model, after reading so much, is getting confused. It is citing something which is not there.
Well, that
Three,
is
four
the reason.
occasions this has happened.
That is the reason.
And the lawyer is blamed.
What helped from your lordship, that exact word, hallucinated version.
No, the problem is that the lawyer is not unwittingly, lawyer has asked the question.
Yes.
He has given a judgment. X versus Y.
Yes.
And X versus Y, it has read as a moot court problem in NLU or in
Exactly. Yes.
So that creates a...
That's the problem.
I mean, many times you find that the lawyer is at the receiving end for the wrong reasons.
Yeah.
Yes. Okay. The CP number, as the MAT case number 47 of 2026, pending before the learned judge, civil judge, senior division, Nuapada, to the Court of Learned Judge, Family Court, Bhubaneswar. It is submitted that the CP has been filed by the husband in the marriage, present opposite party, seeking dissolution of the marriage and grant of decree of divorce under section 13 into bracket 1 into bracket I-A, then comma I-B of the Hindu Marriage Act. So, it is submitted that the present petitioner wife works at Hyderabad.
No,
in Delhi. In Delhi, the husband works at Hyderabad. The husband works at Hyderabad. And Nuapada being it is western and northern.
Extreme western.
Nuapada being at the northwestern border of Odisha, of the state. The distance is more than 450 kilometers. They submitted that for attending the matter, the petitioner finds it difficult. And already an order 9 rule.
Order 5 rule 20.
And order 5 rule 20 has been passed by the learned court, after which she has appeared before the learned court at Nuapada. So notice along with this order. So notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Within 5 working days. Returnable date will fix to 10/8/2024. The matters shall be listed for orders in the week commencing 17/8/2024. IA 203 of 2026 had run its senior advocate for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Stop. Then para accept one set of process fee as well as question repeats. Stop. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the MAT case number so and so pending before so and so shall be adjourned to a date beyond 24/8/2026 as it be convenient to the learned court in session of the matter upon a prayer being made for the said purpose. Urgent certificate copy be issued as per.
Not item 6.
6 6টা কোন লাগে?
Asho.
আচ্ছা ঠিক আছে। বেশি বাটা যায় না? 6 so
Item
Kumar
6.
Das for the petitioner.
That the wife held the petition for transfer of the Guardianship Act filed by the husband before the Court of Law and Judge Family Court Council to the Court of Law and Civil Judge Karanji.
Ground sir? What is the ground?
Grounds, my lord, now the petition is lady and suffering, my lord, and the child are with the husband. And one matrimonial case already your lordship granted stay, that is the divorce case filed by the husband, that is filed by me for transfer of the case, which is sub judice before this.
ସବୁ କଥା କହିଲେ କୋଉଠି ଟ୍ରାନ୍ସଫର କହିଲେନି?
Karanji,
Karanji.
Karanji. Civil Judge Karanji.
Had noted counsel for the petitioner. The petitioner is the mother of the minor child. Opposite party public respondent in the guardianship case number 08 of 2026 pending before the learned judge family court Keonjhar. C6 transfer of the said guardianship case to the court of learned civil judge senior division Karanji. ତାଙ୍କର ସିନିୟର ସିଭିଲ ଜଜ୍ ବି ଥାଏ କୋଉଟା ଠିକ କୋଉଟା?
Now, my lord,
ସିଭିଲ ଜଜ୍ ସିନିୟର ଡିଭିଜନ କରଞ୍ଜିଆ
now, my lord, senior civil judgment.
ସିନିୟର ସିଭିଲ
Yes,
ଜଜ୍
ma'am.
ସିନିୟର ସିଭିଲ ଜଜ୍ କରଞ୍ଜିଆ
Ma'am.
in the district of Mayurbhanj. It is submitted that the petitioner stays at Karanjia at her with her parents.
Parents.
ଆପଣ କିନ୍ତୁ ଆଡ୍ରେସ ଦେଇଛନ୍ତି କେନ୍ଦୁଝର
My lord,
ଆପଣଙ୍କ ପ୍ୟାଟର୍ନାଲ ହୋମ ର ଆଡ୍ରେସ ଦେଇଛନ୍ତି
Karanji, my lord. Your lordship kindly see the cost state. Karanji state, that is Sagada, PS to Raikala, PS Ghagrabada, district Mayurbhanj. Cost state.
daughter of Satish Chandra Barik, village Satasingha near Mongala Mandira, Keonjhargarh.
See this. My lord, see. That is
At village Sagada, post Raikela, the district of Mayurbhanj, and she finds it difficult to attend the matter at Kendujhar. It's further submitted that CP रे जोटा कहते हैं रेफरेंस अच्छी अपन पाखरे
paragraph 5 CP TRPC number 450 2025.
that in CP number 155 of 2025 has been filed by the husband under seeking divorce, seeking decree of divorce, and TRPC number 450 of 2025 has been filed by the wife seeking transfer of the said CP to the court at Karanjia. It is submitted that notices have already been issued in the said CP. It said TRPC. Issue notice to the opposite party along with this order requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within
3 days.
within 3 working days. Returnable date be fixed to 10/8/2026. The matter shall be listed for orders in the week commencing 17/8/2026. IA 168 of 2026 had noted counsel for the petitioner. He reiterates his submissions as noted above. So notice as above, accept one set of process fee as well as postal requisites. So the returnable date as well as the next date of listing shall be as directed above. As an interim measure, it is directed. The guardianship case number 155 of 2025 pending before the learned judge family court Keonjhar shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter.
Guardianship
And a prayer being made for the said purpose.
Guardianship 8 है 155 टा CP गार्डियनशिप केस नंबर 8/26
वो आपण जो कॉपी पेस्ट कला बेले एटा कर दी छथि
ना ना नहीं आगे हेतु
इफु की
नहीं 8 लिखित माइलो 8 लिखित
देखंतु आगे देखंतु आपण जदी ओटे सिंपल
Prayer of
करिवे वेरी सिंपल एंड स्टेट पढिबे
तो पैराग्राफ 1 ले मिस्टेक हे जायछि पैराग्राफ
पावर पॉइंट आपनकर प्रेयर थिला जे देखिबेनी बोले अनेबेनी
ना ना सॉरी मैडम सॉरी प्रेयर ठीक अछि ठीक अछि
पारा नॉट टू बी सीन ना कोन
वन
करेक्शन करंतु ठीक अछि आठ है 2026 आइए लिखिए आरंभ करू is submitted by the learned counsel for the petitioner that inadvertent typographical error has crept into paragraph 1 of the आपण से सीपी रे बाडे दिचली
आगे सीपी रे बाडे
ओटे केस आसला तापर आउरी आसीबो that the inadvertent typographical error has crept into the paragraph 1 third sentence wherein the case number has been wrongly typed. Stop. He seeks liberty to correct the same in the copy of the petition by mentioning the guardianship case number 3 of 2026. Prayer is allowed. The necessary corrections shall be carried out in the court brief to be which shall carry the initials of the learned counsel for the petitioner to be countersigned by the court master. तापर order टा लिखि देबे Yes, next is
item 10.
Mr. Gokha Behra for the petitioner. Opposite party black. Yes, Mr. Behra.
OP7.
Mr. D.N. Leka, additional government advocate for OP7. Yes, Mr. Behra.
My lord, the husband of the petitioner, so he was having some account at a Federal Bank, Bhubaneswar. So he died in the year on 15/9/12. So leaving behind his wife and one children. So they both are residing in the matrimonial home. So after the death of the husband, the mother-in-law ill-treated the petitioner. Although she left the place in the year of 2014. And thereafter, the mother-in-law cunningly filed a interstate case under section 372 of the Indian Succession Act to obtain a succession certificate in order to take back the money deposited in the bank. So without impleading this petitioner and her son, so that case was filed. And subsequently, that case was decided in Loko Adalat. And getting that order, when she submitted it in the bank issued notice to this petitioner because previously the petitioner was receiving money from that bank. So that notice, after getting the notice, the petitioner became ill. She could not approach the bank properly. And subsequently, she came to know that this thing has happened. So after this onward.
The petitioner before this court is
The writ is not maintainable because the order is applicable under the provisions of 384 Indian Succession Act.
No, it is
Loko Adalat order.
Loko Adalat order.
Appeal not maintainable.
The writ is maintainable.
The original order is the issuance of the certificate, succession certificate.
Succession टा Loko Adalat issue ହେଇଛି. Interstate जो ହେଇଛି.
And extra 5 minors.
But problem is that it is
statute.
Loko Adalat re, no, your point is well taken. If it is a Loko Adalat, Mr. Behra says it is Loko Adalat. If you are saying it is not Loko Adalat, then I have to ask him again. You heard your learned colleague. He says that it is not Loko Adalat.
Loko Adalat is there. Civil judge
settle ହେଇଯାଇଛି Loko Adalat रे.
Loko Adalat decided.
Interstate जो suit टा file कले.
Suit टा civil court file ହେଇଥିଲା. So subsequently, during Loko Adalat, the case was transferred to Loko Adalat and it was decided there. Annex 5 minor.
ସେଥିରେ ସେ କ'ଣ जो letter of issue कले. ना letter of
my lord. Annex 5 minor.
Page 40. The order. Senior civil judge, Puri PO bench of National Lok Adalat.
The Lok Adalat appeal not maintainable. Jalor Singh. The only way hochi apanakara writ petition file karibe. Jalor Singh, Bhargavi construction, 3-4 decision of Supreme Court, which I have followed in Madhuchanda. But I have set aside and remanded back. He will say I have a remand habo. But look at Jalor Singh. Which citation will Jalor Singh versus State of Punjab. State of Punjab and another versus Jalor Singh. JALOUR. Yeah, 2008 Supreme Court 1209.
1209.
1209.
That
Equivalent hochi into bracket 2008 2 SCC 660.
And another model.
That is followed in Bhargavi Constructions versus K.M. Reddy. EIR 2017 SC 4428. I have followed those decisions only. Just applied here in cases.
Another decision is there. The AR
Mukul Bhavan Trust.
yes, K. Srivastava versus M. Mala AR 2022 Supreme Court 2381.
Hey, Jalor Singh is the leading. Every case has followed Jalor Singh.
Minor.
Dilip Mehta, Rakesh Gupta.
That is 2008. What is
Constitution bench. So, Jalor Singh says Lok Adalats have no adjudicatory or judicial functions. Their functions relate purely to conciliation and must be based on compromise or settlement between the parties. Lok Adalat cannot enter into an adversarial adjudication akin to a court of law. That is how appeal is not maintained.
Here a pertinent question of law is there. But the statute provides appeal. These are the judgment law.
No, Mr. Lenka, in every Lok Adalat settlement or decree or award, it is statute, CPC, largely CPC, MACT, like in this case, this guardianship, that interstate succession, Indian Succession Act, and CPC provides for appeal. In MACT, motor accident claims provides for appeal. So, where like civil suit for partition, money decree, it is appealable. But since the Lok Adalat cannot be party to adversarial litigation, it has to be only compromise decree, compromised between the parties. So appeal will not lie. That has been held by the apex court. And the reasoning is very clear. Even in Jalor Singh, they have said at times the behavior of the Lok Adalat is to impose its decision, which should not be. See that, read that Justice Balakrishnan.
Not issuing notice.
Notice has to be issued. Already I have decided 3-4 cases. Decision in this sense, it can only be remanded because the lady, in fact, here is a gross case. The person is never died intestate. The person has his legal heirs, wife and daughter. The in-laws family portrayed him to have died intestate. See, he never died intestate. So, actually, when the bag settles, it settles with an indemnity bond. The claimants will indemnify the bank for any future. So you have to check that whether they have furnished the indemnity bond or not. That would help you. The petitioner before this court is the wife of deceased Siddheswar Raula.
Misra.
Siddheswara Misra. ଆପଣଙ୍କ ଡଟରକୁ ପାର୍ଟି କରିଛନ୍ତି?
ନାଇଁ ତା son.
Son.
Satya Misra.
See along with the son of the deceased Sri
Satyanarayan Misra.
deceased late Siddheswara Misra have approached this court by filing the writ application challenging the order dated 12/11/2022 passed by the Lauded Senior Civil Judge Puri in Interstate case number 4/2015 in National Lok Adalat. The interstate petition was filed by the in-laws of the present petition number 1 and
She's the mother of the
mother. The interstate case was filed by the mother of the deceased Siddheswar Misra. In pleading, ମାନେ ହଉଛନ୍ତି brother and sister.
The ଭାଇ ପୁତୁରା ଭଉଣୀ ଏମାନଙ୍କୁ କରୁଛି।
Impleading the family members of the deceased without the present petitioner wife and the son being made parties or made parties. It is stated in the said application, copy of which copy of which has been annexed to the present writ application at paragraph 1, page 17 of the that the late Sri so and Siddheswar Misra, son of so and so, died intestate up to Honorable Court, Para. So Behra Lauded Council submits that the fact remains that late Sri Siddheswara never died intestate. He is survived by his wife and son, both with the legal class 1 legal heirs. Para. It is submitted that the award of the Lok Adalat, not at Lok Adalat, page 12/11/22.
Page 40.
44.
40.
40. The order dated 12/11/22 is vitiated in view of the suppression of material fact before the court. Having heard on his counsel for the petitioner, this court is of the considered view that the petitioners have made a prima facie case as per the principles laid down by the Honorable Apex Court in Jalor Singh in State of Punjab versus JALOUR, Jalor Singh and others, followed in Vargavi Construction and others, that is on the way, and also followed by this court in Madhuchanda. So and so, disposed upon so and so. Issue notice to the opposite parties along with this order by stop order. Requisites for issuance of notice by speed post with AD, speed post with registration and proof of delivery shall be filed within 3 working days. Bank party କରିଛନ୍ତି ତ?
Bank party.
The lauded AG upon advance copy served and appears on behalf of P number 7. अगर property थिला interstate succession रे government को पड़ेला घर द्वारा थिला
the property ଥିଲା ବୋଧେ ସେଇଥିପାଇଁ ମୁଁ ଦେଖିଲି exactly ମୋ ମନ ପଡୁନି ଦେଖି ଆଉ examine it.
Copy ଦେଇଛନ୍ତି ଆପଣ? Copy of the writ petition has been served on the lauded by AG. No further notice be issued. Stop. Yes, next. Yes, Ms. Misra.
11.
The date that Mr. Behra, I'm sorry, I have forgotten the date. The returnable date be fixed to
10/8.
10/8, the matter shall be listed for orders in the week commencing 17/8. Order से आसियो sufficiency of notice. Returnable 10/8. Miss I Misra for the petitioner. I Misra for the petitioner. The learned counsel for the petitioner seeks further time to obtain the present correct address and file postal requisites for issuance of notice to the sole opposite party. Accordingly, further 2 weeks time granted. On filing of the requisites, press requisites in the present correct address.
Your Lordship, may I request something? Kindly direct the local police to serve the requisites.
Local police cannot be involved in a matrimonial matter when more so when a lady is there and she is not a defaulter. You should have thought about this before submitting. Then why is local police so simple and why the local police is not provision is not made in CPC? That police notice is directed by Supreme Court. It is a 141, 142. In case where they are avoiding and evading that way. ଆପଣ ଦସ୍ତି ବୁଝନ୍ତୁ ଯଦି ଦସ୍ତି ନେଇ ପାରିବେ still you can take but I cannot direct because I do not know what is your stand. Correct address 3 weeks time नियंतु 3 weeks time नियंतु the notice be issued afresh to the opposite party. Unutilized copies if any shall be unutilized requisites if any shall be utilized. ଆପଣ ତ ଷ୍ଟେ ଅଛି ନାହିଁ ପରା କହୁଛନ୍ତି ତାହେଲେ what is the stake ଆପଣ କଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି?
We are challenging the early disposal of the proceeding along with the civil proceeding and criminal proceeding both.
ଆପଣ early disposal ଚାହୁଁଛନ୍ତି?
Yes, Your Lordship.
The notice sufficient ଦେଲେ କଣ ହବ? There is a direction by the apex court constitution bench. What High Court should not do, it is doing every day. That comment is there. Justice Oak's comment. I will not follow that. Like in the morning today, Mr. Dey said that I will distinguish two Supreme Court decisions. এটা କିଛି ତାହେଲେ ଠିକ ଅଛି ଏଥିରେ ଆପଣ notice ନ ନେଲେ ବି ଚଳିବ. Early disposal, this High Court cannot pass orders. Only that order I am passing that incorporate unnecessary adjournment nebeni. Have you read that constitution bench decision? Go through that. Allahabad High Court Bar Association, which has overruled earlier ACN resurfacing. Automatic vacation of interim order was considered by the constitution bench and said that no, cannot be. Yes, next. Next. The date can also. They not requisite, sir. Liberty to mention like this.
Item 12.
Mr. Ramesh Kumar Agarwal for the petitioner.
May I please, Your Lordship? Your Lordship, on behalf
I'm sorry, I forgot your name.
Adyasha Mahapatra.
Ms. Adyasha Mahapatra for the opposite party. Yes.
Your Lordship, on behalf of my senior advocate Chitaranjan Barishal, I prefer and sought adjournment. Due medical emergency is unable to present before the Honorable.
This is listed for what, Mr. Agarwal?
Your Lordship, last time since Your Lordship directed that family court is in session of the matter and there was an apprehension from the other side that I may take the child out of the territorial jurisdiction of this Honorable Court. So therefore one affidavit.
You are for the father?
I am for the mother.
You are for the mother?
I am for the father.
I'm sorry.
So therefore one affidavit I filed before this Honorable Court and your
copy has been filed there also.
Your Lordship. Since Your Lordship was of the opinion that family court is in the session of the matter and therefore I filed that affidavit before the learned family court on 3rd of July, Your Lordship. And the matter is fixed to 20th of July, Your Lordship. I have already served a
So at least that apprehension and now at least, I use the language I think assuaged or something I have used the language. So that apprehension is no more there.
Yes, they have
Okay,
given the
so
order.
you take a date. So appearance affidavit आपण आगुरु मध्ये ଦେଇଥିଲେ, I have recorded.
My lord, since I presented here, your lordship was of the opinion that since learned
No,
family,
your file.
your lordship, on
Okay,
3rd of July.
the matter shall be listed for orders in the week commencing. Hard ordered counsel for the parties. The matter shall be listed for orders in the week commencing.
Only request, my lord, short date if your lordship can accommodate.
From next date केबे अछि?
20th July, your lordship.
Satish sir ठीक अछि ताले?
My lord.
27.
Satish.
Yes.
Yes. Yes.
Best.
Apprehensive बोलतो नहीं. One advice and request is that don't be apprehensive about each other. Apprehensive, thore apprehension monare asle it creates to lot of imagination and yes, next.
May
13. I am for the petitioner in this case.
You are Mr. Swain.
Yes, your lordship.
J. Swain for the petitioner. Ms. Kiran Raut for the opposite party.
Yes, my lord.
Yes.
In this case, lordship, the petitioner challenging the ex parte judgment dated 24/2/2025 passed by the Learned Family Judge Kendrapada, wherein the opposite party number 1 claimed to be the wife. Opposite party number 2 claimed to be the son of the petitioner.
Yes.
In view of the order dated 15/1/2026 passed by this Hon'Ble Court, the petitioner already deposited 2.5 lakhs. Also file a petition for recalling the ex parte order. On the other hand, both the parties are in process of settlement. Therefore,
yes, deposited.
Yes, your lordship. Already filed. Memo already filed. Receive already filed.
But they have told in the last date that they will give me the Xerox copy of the deposit. They have not.
In
No.
In course of the I will serve all the copies.
And
All those
also,
copies I will serve.
in the court, it has been directed that the amount will be deposited in a nationalized bank. But last time senior was placed that it was deposited in the court.
In a lot, sir, already deposited in Nationalized Bank.
সেটা ক্লিয়ার ଅଛି সেটা যদি
clear
ଏପଟ ସେପଟ ହବ ଆରେ ବେଳେବେଳେ ଆପଣଙ୍କର କଣ ହୁଏ କି ସେ ହୁଏତ ରଖିଦେଇଥିବେ but the order is very clear shall be kept in a high interest bearing fixed deposit in a nationalized bank with auto renewal clause. So they will comply. Maybe immediately they did not. 4 दिन ପରେ କରିଥିବେ. Referring to the order dated 15/2026, 15/1/2026, it is submitted by the learned counsel for the petitioner that the observations, public directions as made at paragraph 8 have been complied with. Stop. The learned counsel for the opposite party submits that the details of the deposits and other papers have not been handed over, though it was stated before this court. Stop. The learned counsel for the petitioner shall hand over the copies of the deposits made, public draft, before the learned executing court by tomorrow, within 2 working days.
2 working days.
Within 2 working days on the learned counsel for the opposite party. The matter shall be listed for orders. Madam, try for a conciliation. Con best he paribo.
Yes, madam.
Say amount at least the purpose is, madam, that Madam Raut, that at least the lady is now assured of that amount.
Yes, ma'am.
But what would be the future course of action or how things will happen? You discuss. Use your good offices to discuss with the senior Mr. Parikh or whoever, Mr. Swain. The matter shall be listed for orders in the week commencing.
I have.
So, Behra, you are there.
Yes, Lord. There is the talk is settlement is going on between the parties.
3/8 ଆସୁ
3/8 ନାହିଁ ସେଟା ଅଛି 18/8 କୁ 18/8 ପରେ ଆସୁ
ମାନେ ଅଗଷ୍ଟ 18 କହୁଛନ୍ତି
ଆଜ୍ଞା
the week commencing.
ଆଜ୍ଞା
Recall petition ଟା ସେଇ ଡେଟ୍ କୁ ଅଛି ଭାଇ।
ହଁ ଆଜ୍ଞା ଆଜ୍ଞା
24/8
ଆଜ୍ଞା ଆଜ୍ଞା
Interim order ଟା
Obliged. Interim order.
In view of the conditions to be complied with, conditions directed to be complied with having been complied by the petitioner, the interim order date ta kahibe
11/5.
ସେ 15
11/5/2026 adjournment ପାଇଁ ହେଇଥିଲା।
On the application of for adjournment, it is being adjourned.
ଆପଣ ପରା କହୁଛନ୍ତି ଏକ୍ଜିକ୍ୟୁସନ ଟା 18 କୁ ଅଛି
ଆଜ୍ଞା
ଆଡଜର୍ନମେଣ୍ଟ ହେଲେ କେମିତି ଟେକ୍ ଅପ୍ ହବ? କନଫ୍ଲିକ୍ଟିଂ ଅର୍ଡର ହେଇଗଲା ଦିଟା ଯାକ।
ନାଇଁ ସେ ରିକଲ୍ ପିଟିସନ ଟା ଅଛି।
ସେଇଟା ଅଛି ଆଜ୍ଞା 15 ତାରିଖ ଅଛି ସରି
ରିକଲ୍ ପିଟିସନ ଟା ଅଛି 18।
ଏକ୍ଜିକ୍ୟୁସନ ଟା 15 ତାରିଖ ଅଛି 15/7
submitted by the London Council for the petitioner that the ex.cr.p. number 28/2025 is posted to
15/7
15/7/2025 2026 the same date upon a prayer being made for the first upon a prayer being made seeking adjournment, the matter shall be adjourned beyond a date. Eta kebe ko rahila
24
beyond a date shall be adjourned beyond 28 upon a prayer being made for the state purpose.
Pardon me, Lord. As because the admission session is going on, out of that deposited amount in the nationalized bank, minimum 50,000 may kindly be directed to be released in favor of the petitioner, opposite party, so that she will continue the study of the boy.
Itre petitioner jo jio.
Yes.
The petitioner number 2 yes, Mr. Mehra.
Yes, Lord. Lord, the entire relationship is in dispute. That is why
that is the weakest point of your case. In a 125 application, when you start disputing the relationship, the fate is known.
No, fate is known because Lord, it is completely expiry.
And this has been tested before the Supreme Court, Mr. Behra. Now, in a similar matter, it is good that it went to the apex court, and apex court has this condition was tested before that deposit of money.
Lord,
and apex court has approved that.
It
did it to the judgment and upheld the judgment.
It is not wise on my part to stand on the way, but the fact of the case, Lord, so however the talk is going on.
With your experience, you know what is to be done, not 125.
No, that in
125, the weakest defense is that I am not related, because 125 has been expanded to the extent that I mean staying together is enough. Must lead to judgments.
There is ample evidence. The case is
ample evidence. Ample evidence are kutre debe.
Aya olga pura completely सब collection ହେଇସଲାଣି।
ample evidence 125 रे देबेनी आपण ସବୁ ଜିନିଷ କଣ ମୁଁ ଆର ପଟକୁ ଯାଇକି ଆଉ ଥରେ ପ୍ରାକ୍ଟିସ କରିବି ନା କଣ?
ଆଜ୍ଞା ମୁଁ ଜାଣି
ବହୁତ ଫ୍ରି ଆଡଭାଇସ ଆଜ୍ଞା ବହୁତ
ଥାଉ ସେଟା ନେକ୍ସଟ ଡେଟ୍ ପରେ
No, my lord, the admission session is going on. And
ଆପଣ ଗୋଟେ application file କରି ତାଙ୍କୁ copy ଦିଅନ୍ତୁ। Now we must understand that they don't have anything to seek answer. ଆପଣ ତାଙ୍କୁ ଗୋଟେ application file କଲେ ତାଙ୍କୁ copy ଦେଲେ they may work on it.
Yes, my lord.
ଓରା ଦିରେ ଏଡା କଣ ହେଇ ପାରିବ? So ଆପଣ ଯେହେତୁ କହିଲେ I just discussed with him. And by next date, all the youngsters will answer that which suit is to be filed in this kind of a situation.
And this
is a homework given to all of you.
Lord and counsel for the appellant.
So he's a reasonable person. I have found that in this kind of matters, he tries to settle, to do something. He has been doing that. So that is how I told him. He may work out on this also. But ଆପଣ ଗୋଟେ application ଟା ଦିଅନ୍ତୁ। ଦେଖନ୍ତୁ ସେଠି ବି ଆପଣ ସେଠି ବି application ଦେଇ ପାରିବେ ତ କଣ ଅଛି? ଠିକ ଅଛି ନା ଏଠି ଦେବି ଯାହା କରିବେ ଦେଖନ୍ତୁ କଣ ଅଛି।
Obliged.
14.
Mr. Apares Bhoi for the petitioner, opposite party blank. No instruction, Mr. Bhoi.
My lord.
Instruction ଆସୁନି। ଆପଣ ଗୋଟେ maintenance file କରିଦିଅନ୍ତୁ plant ନାଁରେ। ଆଉ ହବନି ନହେଲେ ବର୍ତ୍ତମାନ ଯୋଉ ପ୍ରକାର ହେଲାଣି adjournment ଓକିଲ କିଛି ଦିନ ପରେ no instruction.
Instruction ଅଛି ସେ till date 95,000
ସେଟାକୁ ଯାହା ଦେଇଛନ୍ତି ଆପଣଙ୍କର ଆଉଟଷ୍ଟାଣ୍ଡିଂ ଅଛି 3,64,00,000 95 ଆଉ କେତେ ଦେବେ ଆଉ ଡିପୋଜିଟ କରିବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ
instruction ଏଟା
ଲିମିଟେସନ ଦରକାର ଇନଷ୍ଟ୍ରକ୍ସନ ଅର୍ଡର 41
ନା ଏବେ କରେଣ୍ଟ ଦଉଛନ୍ତି Current,
affidavit दियंतु sir current की otherwise
ଆଜ୍ଞା
ଆପଣ ସେଟା record କୁ ଆଣନ୍ତୁ record କୁ ନ ଆଣିଲେ how I will take cognizance of that.
ଆଜ୍ଞା
I strongly believe you
ଆଜ୍ଞା
but every time I believe I falter.
ଆଜ୍ଞା
ସେଟା ଆପଣ ତାକୁ ଛାଡ଼ କୁହନ୍ତୁ ଆଜ୍ଞା affidavit ଦିଅନ୍ତୁ କୋର୍ଟରେ
ଆଜ୍ଞା
ଛୋଟିଆ one table
ଆଜ୍ଞା
ହେଲା
ଆଜ୍ଞା
କୋଉ ଦିନ ଦେଲେ କେତେ ଦେଲେ କୋଉ ମୋଡରେ ଦେଲେ that's it.
ଆଜ୍ଞା
So operates going for the petitioner. The Lord Counsel for the petitioner refers to the order dated 17/3/2026, paragraph 4 and 5, para 3, 4 and 5, and submits that he has received instruction from the petitioner and petitioner shall file affidavit as directed within
2 weeks.
by by 24 ना ता नेक्स्ट वीक केबे देई परिब
अच्छे 24/7
by 24/7/2026 the affidavit shall be upon filing of the affidavit shall file affidavit by 24/7 the matter shall be listed in the week commencing in 8 2026 for orders in the listed for orders the week commencing in 8
15.
Lordship, on behalf of A. Mishra, I am seeking for a short adjournment.
the Mr. for the petitioner.
Yes, Your Lordship.
What's your name?
Simran Maiti.
Simran Maiti. Miss Simran Maiti, on behalf of A. Mishra for the petitioner. Opposite party, Sujati. Anyone there in the VC? अपन के बाहर कुछ नहीं ना उड़ा का टाइप कर दो से बात जो तो वेटिंग रे थिबे petition opposite party none this is item 50. The matter was had at length on 18/2/2026. At some length and on common. The facts in brief as well as the propositions of law were noted. Thereafter it was adjourned on 19/3/2026. 12/5/2026. Today the matter being listed for orders. Adjournment is sought for on behalf of the counsel for the petitioner. To grant further opportunity to the petitioner, the matter shall be listed in the for orders in the week commencing 3/8/2026.
Published, Your Lordship.
Next,
17.
my lord. The learned counsel for the petitioner being present at the virtual court, High Court of Orissa at Hon'Ble addresses arguments. You have to await sufficiency of notice, Mr. Devata. The notice issued, the notice on admission issued by order dated April. Order 17/4/2026 is yet to be sufficient as per the note put up by the registry. Awaiting sufficiency of notice and appearance of the opposite party, the matter shall be enlisted for orders in the week commencing 3/8/2026. The registry shall do well to obtain the updated postal tracking report as well as report of the as well as report regarding sufficiency, report regarding service of notice and return of AD. The interim order dated 17/4/2026 is reiterated अपने the execution proceeding executing कौन लिख ले वो लिखी रिटायर करिए execution proceeding number 11 of 2025 pending report the learned judge family court arising out of criminal case number 31 of 2025 shall be adjourned to a date shall be adjourned beyond date केवे कहले आपण
मतलब 3
beyond 10/8/2024 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose 3/8 रे आसु ओबलेट माइला yes next
18
Pardon, I'm Mr. Mahapatra Madam.
yes please
It's not come to court matter as a vigilance matter.
Mr.
Upon that.
He's all right.
Madam.
His health is good. Otherwise,
No, otherwise it's good, but
Okay,
last night some
Mr. Ponda, Mr. P.K. Ponda, on behalf of S.N. Mahapatra for the petitioner, adjournment is sought for in absence of the learned arguing counsel due to personal difficulty. So the matter was heard at some length on 25/2024. The facts as well as the propositions of law were noted. Stop. To grant further opportunity, the matter shall be listed for orders in the week commencing 10/8/2024.
19
The Nadako T.K. Mahanti. Mr. T.K. Mahanti for the petitioner, opposite party blank. Office note put up by the registry indicates that notice on admission issued to Solo P by speed post with AD has been returned undelivered. Stop. The learned counsel for the petitioner submits that efforts shall be made for discovery of the present correct address and appropriate steps shall be taken. Prayer is allowed. 3 weeks time granted for obtaining present correct address and filing requisites address. Stop. Upon filing of the requisites, notice be issued by the registry fixing a returnable date. Notice shall be issued. Things of the new to stay अच्छी ना नहीं?
No.
Stay है नहीं. अपन तो enhancement ना कौन सा? Execution file कर चुके हैं. और सेटा अपन से सप्लाई जो advice है कामर लगा तो.
No, I have consulted take an interception.
When the other side is not responding, अपन ये कहवे जे आगे same address इथरा गलानी तो कौन तारा leads to nowhere. You have crossed the line. Rest of the matters after recess. Judgment should clear.
item 20
Recording in progress.
File already filed, Mr. Pradha?
No, Lordship, I cannot file because of she wants to, she arranged the address but could not file, but the address what the petitioner has filed in the code below, that was the address.
The problem is that there can't be any presumption of service.
No, my lord, though address has given by the opposite.
Because this issuance of notice by this court is a physical act.
Yes, Lordship.
It's a factual thing.
So I have,
there can't be any presumption.
no, my lord, I have given the address, those address I have given,
When you are saying no, my lord, what is no, my lord?
but I am submit, my lord.
No, this court has not issued notice.
No, notice issued.
So the notice issued. So notice has got.
Yes.
There is a report of non-service. Correct.
Yes.
You say that since the same address is there before the court, so it should be treated to be sufficient.
Lordship.
Under which provision?
But I could not say. I have no knowledge about it.
I do not have a knowledge also. I seek your assistance.
So
because a physical act of service to be presumed,
Lordship.
there are some case laws. There are some case laws on this. Correct. But that also, suppose somebody receives and refused and left without notice. But again, the problem is that presumption of service will not end up in making the notice sufficient. Ultimately, it may result in a decision in the absence. Will be set ex parte. Correct. So we have to make some effort in serving the notice.
So I pray for another opportunity given to the petitioner to find out the address
So,
from this.
so it was given. So that I'm directing, but it's when I was dictating the order, you interjected.
Yes, sir.
So Deepak Ranjan Toida for the petitioner. It is submitted by the Land Council for the petitioner that despite efforts, the present correct address of the opposite party could not be ascertained, and some further time may be granted accordingly for the 3 weeks. It's stay.
Yes, sir.
You should be least concerned. Receive college, receive no period. The further 3 weeks time granted to discover present correct address and file requisites for issuance of notice. Upon filing of such requisites, notice shall be issued, fixing returnable date. Interim order in the interim order dated so and so is 48/3/48 is reiterated. The CP number 34 of 2026 shall be adjourned to a date beyond 17/8/2026 as will be convenient to the London Court for in the season of the matter. The matter shall be the present matter shall be listed on for orders in the week commencing 10/8/2026. See, could appear kurchonti. Is he appearing before the trial court?
Before the lordship.
State apana safety notice diyantu at the best. So now why I am saying this because that is also an experience of me. Sitting. A matter he was supposed to appear in Puri. Notice was sent to Puri. The report comes that he never appears in Puri. So I mean there are so many angularities to here. Upon jodi se appear korchonti gote CP re ki execution re special. Usually execution re appear karanti. So upon seti notice deki court through re lawyer and person reparibe. But you have to have the definite information. Liberty to mention. Jodi apana say court re author requisite debe court through re. You obtain that instruction. You
Yes.
mention the matter.
Yes, sir.
Otherwise you find out.
Yes, sir.
Once the matter is stayed and he is not taking interest for us, it is a strategy on their part also.
Order ta 20/3/26 rehta.
Who is say kochi 20/3/26? Yes, next.
Item 21.
I am for the petition.
Notice ସେ ସିଗ୍ନେଚର ଟା କରିନାହାନ୍ତି କଣ କରିବା ତେ ଅଛି
No.
ଏଣ୍ଟ୍ରି ଅର୍ଡର କଣ ଅଛି you are Mr. Koran
GB Parida.
Mr. GB Parida for the petitioner. Though the notice has been issued by a person who was signed as court S.SAHOO, which apparently could be the opposite party, Subhendu Sahoo, within court. No one appears for the opposite party. Awaiting appearance of the opposite party, the matter shall be listed for orders in the week commencing 10/8. Is he appearing before any proceeding before any court?
No.
जोटी appear करूछंती सेठी आपण कोर्ट थ्रू नेले सुविधा हो बुझंतु liberty to mention
The instruction.
specific instruction दियंतु in any proceeding where he is appearing.
No.
So you take I'll direct that notice be sufficient to the office of the court where he is appearing. And that is without almost fail that happens. Okay. Yes, next please.
Item 22.
In 22, I'm appearing on behalf of Mr. Debokanta Mahanti.
I'm from the opposite party, filing
Mr. Satabdi Samantray on behalf of Devakanta Mahanti.
Yes, Your Lordship.
For the petitioner. Apanakar nada sir?
Silas Patra.
Silas Patra. You and associates or who?
Sir, associate NP Patra.
Sorry sir?
Niranjan Prasad Patra.
Mr. NP Patra along with Mr.
Silas.
Opposite party black. Notice issued to the opposite party has been received with signature of Narin Samantarai as indicated in the office note. Sri NP Patra along with Sri Shailesh Patra appeared on behalf of the opposite parties. Oklatnama shall be filed in the registry during course of the day today. Course of the day. Scanned copy be updated. Name of Mr. NP Patra as well as Mr. Learned Counsel and Learned Associate shall be indicated in the cause list as well as case brief appearing for the opposite party. Yes, what do you say? Instruction Nachi. The matter shall be listed for admission in the week commencing.
10/8.
10/8.
Yes. Interim
order dated
22 April 2026.
22
2024 is reiterated. CS number 113 of 2017 and CS number 634 of 2013. Se order ta khali pura
interim order
ଆପଣ କେବେ ରଖି
10/8.
shall be adjourned beyond 17/8 to a date as would be convenient to the learned court in season of the matter.
23.
My name may be, I am appearing for petition.
ଆପଣ ତ ଦେବକାନ୍ତ ମହାନ୍ତି ଥିଲେ
ନାଇଁ
ବଦଳି ନି ତ
ନାଇଁ ବଦଲି ମୁଁ କହିଲି ମୁଁ ନଥିଲି ତ ମୁଁ ଦୌଡ଼ିକି ଆସୁ ଆସୁ ଟିକେ ଥିଲେ
ସେ ଟିକେ ଲେଖିକି କହିବି ପରେ ଦେବକାନ୍ତ ପୁରା କରିଦେବି ନା କଣ?
ନାଇଁ ନାଇଁ ଠିକ ଅଛି
ଶ୍ରୀ ଦେବକାନ୍ତ ମହାନ୍ତି along with Ms. ଶତାବ୍ଦୀ ସାମନ୍ତରାୟ। ମୁଁ ତାଙ୍କୁ ବି ନା ପଚାରି ନାହିଁ କାହାକୁ ନା ବିଲକୁଲ ଅପଚାରି ଲେଖିଛି ଆଜ୍ଞା ମନରୁ ଲେଖିଛି ଆପଣ ଏମିତି ଗୋଟେ କହିଲେ କେମିତି ହବ?
ନାଇଁ ନାଇଁ ମୁଁ ସେଟା ଶୁଣି ନଥିଲି ତ ତେଣୁ ମୋର ମିଷ୍ଟେକ୍ ଏଇଟା
ନାଇଁ ନାଇଁ you have to have your sense of humor intact, otherwise difficult to I mean the pressure you have to bear as a lawyer or as a maybe I can't say as a judge.
ସେ ମୁଁ ଫର୍ଚୁନେଟ ଆମର ଏଇ ଜଷ୍ଟିସ ଶଶିକାନ୍ତ ମିଶ୍ର କୋର୍ଟରେ ସରିଲା ତ ମୁଁ ସାଙ୍ଗେ ସାଙ୍ଗେ ପଳେଇ ଆଇଲି
She did it more than enough. Yes.
Item 23.
ଆପଣ ଅପୋଜିଟ ପାର୍ଟି ପାଇଁ ନୁହନ୍ତି ସାର୍?
ମୁଁ ପିଟିସନର
କଣ କରିବା ସାର୍ ପର୍ସନାଲ ସର୍ଭିସ ହେଇଛି ଆୱେଟିଂ
ପର୍ସନାଲ ସର୍ଭିସ ହେଇଛି
କଣ ଷ୍ଟେ ଅଛି?
ଷ୍ଟେ ଅଛି
ଷ୍ଟେ ଅଛି ସେ ଆପିୟର କରିବେ ତାଙ୍କ କଥା ସେ ବୁଝିବେ ଆଜିକାଲି ଗୋଟେ ସେଟା ଷ୍ଟ୍ରାଟେଜି ହେଇଗଲାଣି The husband and wife are fighting before the court, but they are completely in hand in glove in postponing the matter. Could be. Mr. Prafulla Kumar Kaur.
myself DK Ratha.
Mr. D Ratha.
DK Ratha.
भूल है
सेटा नाटा भूल
Mr. पूरा नाटा
दीपक कुमार Ratha.
Deepak Kumar Ratha for the petitioner. Name of Mr. Deepak Kumar Ratha, Learned Counsel, appearing for the petitioner shall be corrected as it has been wrongly typed as D.CORAM. Let's stop. Corrected to like corrected in the cause list as well as the case brief. Despite sufficiency of notice, none appears for the opposite party. Awaiting appearance of the opposite party, the matter shall be listed for orders in the week commencing
10/8.
10/8/2026. The interim order dated 30/4 is reiterated. Should I modify kar debe? Shall be beyond 17/8 kar debe? Yes, next.
24.
Mr. DK Raj, you are Mr. Sahoo.
Yes.
Mr. Devashish Sahoo for the petitioner. Sir, pin code not there to enter haboni na sir.
By Tuesday I'll fill.
Apna pin code taku there is a method you can find it in the web.
Yes.
See exact ଜାଗାର ନଥିଲେ ବି ଆପଣଙ୍କର ତାର ଯୋଉ ଅଫିସ ର ଥିବ ଟିକେ ଆପଣଙ୍କୁ ପଚାରିବାକୁ ପଡିବ ଲୋକାଲ କାଉନସିଲ କୁ
Yes, ma'am.
ସେ କହିଦେବେ
By Tuesday I'll fill.
Mr. Devashish Sahu for the petitioner office note put up by the registry indicates that as the postal index number code into bracket pin code of the address given in the speed post, address given for issuance of notice by speed post is not available. Notice could not be issued. The learned counsel for the petitioner shall furnish the PIN code of the address within a period of 5 working days. Upon furnishing of the PIN code, notice shall be issued fixing returnable date. Patra, MSK Patra for the petitioner. And a postage stamp stop short each. The office note put up by the registry indicates that though the notices were forwarded to the post office to be issued, due to shortage of postage stamp, the same has been returned. The petitioner shall have liberty to provide the deficit postage stamp. Notice be issued afresh. Notice be issued fixing returnable date to 10/8 entry model ଅଛି 17/8 କରିଦିଅ ସେ ଦେବେ ନା postal stamp ଦେବେ ତାପରେ ଗୋଟେ
Monday दे
10 ଠିକ ଅଛି टाइम सफिशिएंट ଅଛି ନାଇଁ ଏଣ୍ଟ୍ରି ମର୍ଡର ଅଛି
बस
ଆପଣ ମନା କରୁଛନ୍ତି
नहीं
कोर्ट
इंटरन पार्शियल इंटर
एंट्री मॉडल डेटेड 2/5/2026 is reiterated shall be adjourned beyond कर दियंतु बड़ 10/8 कहले ना
10
beyond 17/8 next please
item 26
The Lordship, I'm appearing for the petitioner.
Yes.
This is a transfer petition.
What's your name?
Krishna Mishra.
Ms. Krishna Mishra for the petitioner. You are Mr. Sanat Kumar Das.
No, S. Satapathy.
Mr. S. Satapathy for the opposite party. Yes, Mr. Satapathy, an instruction that you'll agree for the place of any place you can suggest where both of you can agree.
My lord, there is a provision of virtual mode. If possible, it will be better.
Instruction given to virtually at times it is called family court matter.
Family court.
Divorce.
Divorce.
आपन काउंसलिंग हेरिका पई तो दरकार जहा लेबी फिजिकल प्रेजेंस से नहले काउंसलिंग हे परियो अदरवाइज वर्चुअल मोड रे हे परियो लाइक सुप्रीम कोर्ट has directed in many cases. So first of all you explore where both of you can agree like Kotak এটা কোটু কোটি
Bhubaneswar to Dhenkanal.
ভুবনেশ্বর ঢেঙ্কানাল তো কটক তো মজা মজি আছে কথা বলতু No, I'm not saying that you now, right now you say. Kotak sir.
Kotak.
Your Lordship, any short date for adjournment because
No, you obtain instruction. I'm not compelling.
if it given before 3rd August, that will be.
Upon the instruction, it can be listed next week.
Your Lordship, because
Third order counsel for the petitioner and the opposite party. The application has been filed by the wife in the marriage seeking transfer of the CP number 228
of 2026
of 228 of 2026 pending before the Learned Judge Family Court Bhubaneswar to the dash English Roman 2 double line to the Court of Learned Judge Family Court Dhenkanal. And the Learned Counsel for the petitioner shall make endeavor to arrive at a amicable settlement acceptable to both the parties by suggesting a place of litigation. The matter shall be listed for orders.
Your Lordship, before 3rd August because CP is listed on 3rd August in the
matter shall be
family
listed in the week commencing next week or week commencing 27. The matter shall be listed for orders in the week commencing 27 liberty to mention. Yes, next please.
item 27
is Chetna Prakash for the petitioner. Same order as in pin code कोथरे नथिला same so 24 Chetna Prakash on behalf of Pinny Misra for the petitioner. Same 24 जहाँ order 37 से order. इटा आपनकर week commencing 10/8 ହେଇଛି. Listed for orders in the week commencing 10/8 27.
Item 20.
Just one second. Check करें entry model. Entry model dated 12/5/2026 is reiterated. So paragraph ta reproduce करते हैं. To be adjourned beyond 17. Yes.
28.
Mr. M. Pagal for the petitioner, opposite party blank. Office note indicates that neither AD nor an undelivered notice as against the sole opposite party yet returned. So, awaiting sufficiency of notice and appearance of the opposite party, the matter shall be listed in the week commencing 10/8/2024.
29.
Mr. Gap.
Your Lordship, on behalf of Mr. Prem Mahanti, sir, he instructed me to
counter not received.
Yes, Your Lordship.
Other time.
No, 4 weeks time, Your Lordship.
Petitioner, come on, standing. Petitioner none. Mr. Prem Kumar Mahanti for the opposite party, additional standing for the opposite party. Is submitted by the on behalf of the Learned Counsel for the Learned AAC. It is submitted by the Learned AAC that further time may be granted. How much time you are saying?
4 weeks.
Further 4 weeks time may be granted for filing of the counter affidavit. Accordingly, the matter shall be listed for orders in the week commencing. Listed for admission in the week commencing 17/8/2026. Yes, next.
Item 30 days simply.
କରିଦେଇଛନ୍ତି ତ ଠିକ ଅଛି.
Item 32.
Yes. Mr. S.R. Behera. Sir, S.R. Behera. On behalf of P.K. Pradhan for the petitioner. Matter was presented before this court on 13/12/2012. Notices were issued by the division bench, as it was then having determination on 29/01/2023. 2013. Very good. Interim order was passed on 29/01/2013. The following effect. As an interim measure, operation of this. Thereafter, the matter was listed before the Lok Adalat on 14/9/2024, National Third National Lok Adalat on 14/9/2024. Thereafter, the matter is listed today for hearing under the heading for admission. Memo of take is filed by the Learned Counsel for the petitioner, which states thus. Apparently, the petitioner, after filing of the matter, is not taking any interest in prosecuting the same. As per office note dated 17/8/2024, the notice has been sufficient on the sole opposite party. the opposite party has preferred not to appear before this court. In such scenario, the purpose would be served in keeping the matter pending. The petition is disposed of. Yes, next.
33.
Question got you.
Will counsel
Did you mention that?
No.
For admission got you too.
34.
File करना है.
Filing.
Secretary करना है. The secretary the list.
20727 ने file है ये
35958 counter not received. Mr. Naik, in your matter, senior is appearing also.
In this case, they have not filed counter evidence. That is a question of payment of gratuity.
Same point of view. So also, man, you take instruction. Can you adopt that counter here?
Your Lordship, I'll do that. 3 days for the
Yes,
instruction.
2072-34, 20727, you have filed counter.
Yes, Your Lordship.
35958. I thought that both Mr. Das is appearing. Initially, I was thinking in those things. So when you said that I was looking at him, that's a different matter.
May I say one thing, Malad?
Yes, yes.
It's the payment of gratuity to the aided college lecturers, Malad. It's squarely covered under the enactment itself. And the lecturers of the government colleges also, they're getting gratuity at a particular scale. But what the stand they have taken, Milad, in the counter is that economic capacity of the government, number one, and they cannot claim it gratuity as a matter of right. Now, these are the two stands they have taken. And they again taken the stand of section 7C, which is not inconsequential as far as this is concerned. We are not paying for any grant in aid. It's a statutory entitlement of gratuity under the Gratuities Act. I mean, not only Gratuity Act, but also the provisions that is Odisha Aided Educational Institutions Employees Retirement Benefit Rules 1981. But if it is that book, is at page 885.
885.
Yes.
Odisha Aided Educational Institutions Employees Retirement Benefit Rules 1981.
Exactly.
Yes.
Lordship may kindly come to Rule 8.
Yes.
An employee shall be eligible for a gratuity if the period of his qualifying service up to the date of his retirement is 5 years or more, but less than 10 years. The gratuity shall be at the rate as follows. Completed years of qualifying service, 5, 6, 7, 8, 9, and scale of gratuity. Here in this present case, all have completed 9 years, 7.5 months emolument.
You are citing any case law on this?
Yes.
So, Chancellor, you have to prepare on this because you have to respond. Full-fledged hearing it prepares.
The only response on their part is that the financial capacity of the government, Section 7C of the Education Act, which is highly inconsequential in the matter, and gratuity is not a matter of right. All the three propositions with you answered. Yes.
So that I was anticipating. So I mean, before I just so in the concern that he has to answer those three propositions. I mean, whatever propositions of law.
Yes.
You have to answer specifically by if any case law is cited. Can you keep the citation on that so that he can respond?
Yes, Malad. And Lordship kindly recollect the judgment from which the entire thing flows is DS Nakara case. AIR 1983 Supreme Court, page 130. When gratuity is provided under a particular statute, and it is a subordinate legislation,
83 Supreme Court.
Page 103. Sorry, 130.
130.
My lord, if you have not wasting my lord's time, my lord, only 2-3 minutes, my lord.
Yes. No.
My lord,
Because
first,
usually I'm not opening briefs right now.
yes, my lord, I will also not open, my lord. Because
no, in the sense ki I'm not starting hearing a fresh matters which I've already have had.
yes,
I'm trying to conclude that matter.
correct, my lord.
But one thing is required that the other side should have also the grip and they should prepare. So that is why I'm just drawing his attention so that he has to respond to whatever submissions and record those submissions.
Yes. What does Nakara say, my lord, if I put to myself? Nakara says Article 14 and 16 with regard to employment in service and intelligible differentia. That is the most important the words in that. Now, what is intelligible differentia if I put to myself? If there is an objective to be achieved, for that, to achieve that object, there ought not to be any differentiation between the set of people who are supposed to achieve the objective. But when there can be differentiation, so as to achieve the objective, if a minority of who are aspiring to get the objective done, they are neglected and the majority is achieved, that is called intelligible differentia. And here, my lord, what is the rule and what is the Gratuity Act? Gratuity is not, it is not as has been said in AIR 1991 Supreme Court page 101, that it is not a bounty like pension, my lord. It is a statutory entitlement of a particular employee. If a statute provides for a particular thing to be done in a particular way, it has to be done only in that way, no other way, my lord. And statute provides that, so you are bound to pay. Once, and lordship will see the impugned orders are by only memorandum and resolution. If one looks at Article 13, Clause 3 of the Constitution, what would include, my lord, a law that is there in Article 13.3? Article 13.3 does not include our memorandum and resolution. And who signs the memorandum and resolution? A joint secretary on behalf of the governor. And those impugned orders say that this Rule 8 is amended. How the Rule 8 could be amended? It is there in Section 27, subsection 3 of the Orissa Education Act. It has to be placed before the state legislature for a rule to be amended. How can an IAS officer, doesn't matter what position he holds, he can amend the rules by a resolution or a memorandum? Well, those are the impugned, my lord. And your lordship knows from my lord's experience from the bar and also in the bench that government role, lack of fund with the government is no consideration. You are paying to the government college lecturers at 15 lakhs gratuity, whereas you will pay an ungovernment college aided college lecturer only 2,50,000. So what is the rationale there, my lord? Then what is the objective sought to be achieved and what is the different intelligible differential? Well, that is the case here, my lord. All answered in judgment. Well, he should be ready to meet all these points, my lord. He can come next week, my lord.
So, first item, WPC 20727 of 2022. So, SS Das, senior advocate, along with Miss Salaka Das for the petitioner. Anshuman Sethi, additional standing counsel for the opposite parties 1, 2, and 3. Counter affidavit on behalf of the opposite parties has been filed. In response to the counter, the rejoinder has also been filed by the petitioner. Rejoinder copy achi apana pakhare? You have received copy. Copy of the rejoinder has been served on the screen. Opening sentence to the matter is listed for hearing under the heading for animation.
No, no, lordship, we haven't yet received the rejoinder copy.
Yeah, I want to but you have copy of
the additional standing counsel requests for an extra copy of the rejoinder, which shall be served within 2 working days. The learned senior advocate summed up, made a summary of submissions that the present petitioners who are the lecturers in non-government aided colleges.
Yes.
Non-government aided colleges. They seek grant of gratuity similar to that of the lecturers working in
Well, all have retired. Well,
government aided colleges.
yes,
Post
retired.
retirement. But referring to the stand taken by the opposite parties in the counter, it is submitted that the opposite parties have relied on section 7 into bracket capital C of the Orissa Education Act, 1969.
And number 2, economic capacity.
To admit that the state can only pay gratuity according to the economic capacity and not otherwise. Therefore, state can decide not to pay the gratuity to a set of employees. It is submitted that there is no intelligible differential between the present petitioners,
Petitioners.
petitioners, retired lecturers, readers from government aided colleges, non-government aided colleges, and those who are in receipt of gratuity. That is the retired lecturers, readers from government aided colleges. It is submitted that apart from that, there being no intelligible differential between the two sets of employees. There is no reasonable nexus with the object to be achieved by treating the set of employees differently, which is violative of Articles 14 and 16 of the Constitution of India. It is further submitted that Article 13(3) of the Constitution of India refers to law includes.
Yes.
The 13(3) provides law. And for the Article 13, Article 13 provides that laws inconsistent with or in derogation of the fundamental rights shall be void. Referring to Article 13(3, it is submitted that the order, rule, regulation, notification of the state government being in derogation of the fundamental right guaranteed under Article 14 and 16. Article 14, 16 continues, 14.
And also 16 in case of employment.
Okay.
14 is in general inequality.
16, 14 and 16.
Yes.
Has to be declared to be void. The allotted senior counsel refers to the decision of the Honorable Apex Court in D.S. Nakara, DS Nakara, colon AI 1983, Supreme Court 130. as well as the decision rendered by the apex court in so and so, AIR 1991 Supreme Court 101, to submit that. Gratuity is not a bounty that the state can decide not to pay, but it is a statutorily defined amount, payment of which cannot be discriminatory between two sets of employees similarly situated. The learned senior advocate submits that he shall make his further submissions on the next date of hearing. The learned additional standing counsel shall respond to the submissions made by the learned senior advocate for the petitioner. The matter shall be listed for admission in the week commencing
20th. 20th.
27
Okay.
27 ଆପଣଙ୍କର କେତେଟା ଅଛି ଲିଷ୍ଟଟା ପଳେଇଲା କଣ ପାଇଁ ଅଛି ମୋର ଲିଷ୍ଟଟା ଗୋଟେ 27 କେତେ ମ୍ୟାଟର ଅଛି 27
27 ସାରେ ଅଛି 143
143 ରଖ 143
ନା ତାହେଲେ ତାପରେ ପଡିବନି କାଇଁ 22
ନାଇଁ 20 ୱିକରେ ସେଟା ଆଡଜଷ୍ଟ ହଉଛି ତାପରେ ୱିକ ହଉଛି 27 7 135 3 8 105
ମାନେ ୱିକ ପୁରା ଏଣ୍ଟାର ୱିକ ରେ
ହଁ ଇଣ୍ଟର ୱିକ ରେ ସେତିକି ଲିଷ୍ଟ ହବ ତା ଛଡା ଆଡ ହବ ଯାହା So in fact, we are now having a kind of live monitoring up to 3 8 we are having more than 500.
ତାହେଲେ ସାର୍ ଯୋଉ ପଡିବ ସେ ସାର୍ ରୋକ
तो we commencing 3 8 थाउ देखिया 105 रे ऐड हो that is a better possibility than 150
ओके
because आ भीतर तो ऐड ही जीवो ना
3 8
तो नेक्स्ट मैटर लिखिबे the matter was 35958 Mr. Pavitra Kumar Nayak for the petitioner, Mr. Ansuman Sethi, additional standing counsel for the opposite party. The matter was taken up along with the WPC number 2077 of 2022, wherein the submissions of the brief submissions of the learned senior advocate for the petitioner have been noted. It is submitted by the learned counsel for the petitioner that despite repeated opportunities, counter has not been filed. The learned additional standing counsel shall obtain instruction and file counter. File counter by 30/7/2026 upon serving copy thereof of the learned counsel for the petitioner. The opposite parties shall have the liberty to adopt the counter filed in the WPC number 2077 of 2022.
Yes.
For a faster लिखिबे the learned additional standing counsel request for a copy region that actually city लिखो तो सिर्फ line add कर दियो तो the learned the opposite parties shall have the liberty to respond to the rejoinder. Yes. So Naik, anything else?
Item 35.
Yes, next 35.
Lord, on behalf of Mr. De, my lord, the application is filed for amendment, my lord. In the meantime, pin number 1 transferred.
Copy. Bujli, I got your point. Since it is a quasi criminal proceeding, proper party should be there. Copy da ଦେଇଛନ୍ତି?
I mean.
35 ରେ Patnaik, I'm sorry, I'm sorry, I forgot your name. Patnaik, first name ta?
Namita Patnaik.
Miss Namita Patnaik on behalf of SK Day for the petitioner. IA number ta? IA 436 of 2026. The IA has been filed for amendment of the cause title, oblique addition of parties in view of the change of incumbency of the opposite party. Stop. Copy of the IA The Lord Additional Standing Counsel shall request for extra copy of the IA,
I have already.
which has been served. Stop. The Lord AAC shall obtain instruction. Usually, ethre allow hoga kata, but you can take instruction. Well, obtain instruction. The matter shall be listed for orders in the week commencing.
No, sir.
10/8.
I'll sorted.
Yeah, 10/8 अपन तो देखिले तब volume we have to handle. 10/8 हेले तब पूर्व के लिए 3/8 हो. 3/8. Secondary भी उटा आइए अच्छी. हाँ आइए second matter है CONTC 2494 of 2022. IA 438 of 2026. For 30 of 2026. Same appearance, sir.
Copy.
In all the three matters you are appearing, Mr. Ansuma?
Yes, sir.
2495 is there. Yeah, 36.
36.
Sorry for the item 29 is non-appearance.
ଦେଖିବେ
Interim order ଥିଲା ପ୍ରହି
ପ୍ଲସ୍ 14 ଅର୍ଡରଟା ମୁଁ ଆପଣଙ୍କ ଆବସେନ୍ସରେ ମୁଁ ଆପଣଙ୍କ ପାଇଁ ଆପିୟର କରିଥିଲି.
ସରି
I have appeared and passed extended interim order. 29 लिखिदेବେ Mr. MR Pradhan for the petitioner. ସେ adjournment ମାଗିଲେ counter ପାଇଁ.
My lord.
Interim order ଥିଲା counter extension.
Interim order. ସେଟା time petition ସେମାନେ ସେଟା
ପ୍ରେମ କୁମାର ମହାନ୍ତି Additional Standing Counsel. ସେଟା ଆଡ୍ ହବ. Interim order ଯଦି ଥିବ ଯୋଉଟା interim order
ସେଥିରେ
continue till the next stage of it.
ସେଥିରେ ମ୍ୟାଟର ଥିଲା କି ସେମାନେ ଗୋଟେ ଓପିଡିଏଫ୍ କେସ୍ ଯୋଉ ଇନିସିଏଟ୍ କରିଥିଲେ ସେଇଟାକୁ ସେମାନେ ଆମକୁ ନୋଟିସ୍ କରିଥିଲେ ତ ସେଥିରେ ମ୍ୟାଟର ଇଏ କରିଥିଲେ କି ସେଟା ଟାଇମ୍ ପିଟିସନ ଦେଲେ ସେଠି ସେମାନେ
Yes, next.
36.
May I please, your lordship? Lordship, I am for the opposite party. Wife, your
withdrawal पर file करছো.
Yes, your lordship. The matter has been settled between the parties.
Ms. Devadipta, Mr. S. Patra for the petitioner, Mrs. Devadipta Sahoo for the opposite party. The matter is mentioned by the learned counsel for the petitioner. He files memo of date which states thus into bracket C. In view of the above, the petition stands disposed of. Copy of the order shall be forwarded to the learned court in season of so-and-so CP number ittek, so-and-so.
Yes, lordship.
Yes, next.
37.
My lord, this matter arises out of a application before the execution court. There is the family court, Raurkela. Lord, next to one.
Mr. Omkar Panda.
My lord.
So Omkar Panda for the petitioner, Mr. Himanshu Shekhar Deo for the opposite party. Yes.
My lord, next to one, there was a order by this honorable court that 12,000, the monthly maintenance was enhanced to 12,000, and there was a 3,000 which was calculated and reduced from the arrear of 4,40,000. At the time of passing of this order, the fact regarding the petitioner's retirement was not brought to the knowledge of this honorable court. So we had filed a review. In the review, the order of review that is in Annexure 2, your lordships had observed that as Section 25(2) under Hindu Marriage Act, we can file, there's a your lordship had provided a liberty to file a application under there to
Because section 25 cannot be exercised by this court.
my lord.
By the original code, obviously there is a provision for seeking enhancement or modification in changed circumstances.
My lord. After your lordship's order, we filed a
25 you have filed.
That is there.
Pending.
Subsequently, the executing court attached my provisional pension. 15,000 has been, they have been deducting 15,000 from my provisional pension. I filed a IA before the executing court stating that my section 25 petition is pending.
Which provision? Filing is not important, provision is important. By which provision of law you can tell the executing court to go behind the decree, decide whether 25(2) is determined or 25 is to bind, and more so after it has traveled to High Court, the appellate court. Under which provision you can interdict the executing court? Because due to pendency of 25(2), this is not to be executed. Because the basic principle, as all of you know, and that the executing court cannot go behind the decree, much less it can modify the decree. Correct. So till 25(2) is allowed, your liability is to pay 15,000. That cannot be altered by any court.
And I have been paying that
so
amount.
Keep on paying. If you are paying, then there is no execution in coercive measure. As a coercive measure, there can't be anything. And even attachment also is not, it is not harming you in the sense it is not to an extent, because the rest of the amount you are enjoying.
Lord, my salary was around 90,000. Now it has reduced to 45,000.
It can never reduce to 45,000. When your client tells you these stories, you are at a different level. Always take the story with a pinch of salt, and this story requires a sack of salt.
Now
no person will receive a pension of 45,000 exactly 50% of. You have to check. You have to check what are the voluntary deductions made by the person. Now he writes a Audi like your senior. Correct. So then it is his voluntary choice to write say Audi like your senior and one Mercedes also. He takes a loan. Or take a lease of a car that it will in fact, those cars are being leased out. After say enjoying the car, you can return it to the company. But you have to pay the amount, like aircrafts are leased out. So that you have to check. Make a study. Don't be in a hurry and read exactly on this point. Very interesting observation of Honorable Justice my Lord Justice Deepak Misra, as he then was, that post-retirement the High Court reduces. Suppose he has taken a commuted value of pension of 15 lakhs. That 15 lakhs is a share goes to the wife also, the child also. Those aspects you prepare. And most of the time, whenever you are, getting these kind of inputs, check and cross-check. Go for the basic document of pension slip, whether actually his pension has been reduced. Then ask him to file that affidavit, let it be tested. And more so, that has to happen in 25(2), which is pending, not here. This court cannot exercise the jurisdiction in 25(2). It will be a complete lack of jurisdiction. 25(2) appeal in MATA, again, I am not having jurisdiction, division bench will have jurisdiction. So if you are paying that amount of 15,000, there is no point in keeping this matter pending, because this will lead to nowhere. As far as your concern is concerned, to pay less amount after the retirement to your wife, that you can achieve in 25(2). 25(2) goes in your favor. Mr. Deo's client will file appeal, or it goes against him, then you may file appeal, or you may be satisfied. Both of you may be satisfied also.
Now the petitioner wants to settle once and for all. And
money, sir, who will give? I can't give money. Can I direct the public money to be paid to the wife?
No, my lord.
You and your wife, you have to settle. And regarding money, there can't be any settlement.
My lord, if it can
Because the
said-
purpose, if you read the purpose is to prevent vagrancy and destitution. So your quality of life at the cost of your wife's life cannot be a equitable distribution. It cannot be equitable order.
My lord, if
So that is how the concept is that the wife continues to enjoy the life what as she was enjoying being married in company of the husband. Of course, not to that scale. If there is a competition that if you are riding a Audi, then she wants to ride a Mercedes. It's not that. But it also can't be that she will not be able to ride anything. She has to walk on the street.
My lord, if my learned senior may agree on a certain amount, I am ready to pay.
ଆପଣଙ୍କର 13 ପିଟିସନ ପରମାନେଣ୍ଟ ଆଲିପନି ରେ ଏଟା ତ 25 ନା
ଆଜ୍ଞା
25 ରେ ଆପଣଙ୍କର ମନ୍ଥଲି ମେଣ୍ଟେନାନ୍ସ ହେଇଛି
ଆଜ୍ଞା 13
ତ ସେଇଟା ସେଇ again 25 ସେଇଠି ହିଁ ହବ ସେଇଟା obviously Mr. Deo can so Deo I think that is a very bona fide suggestion that if you can agree for a permanent alimony both of you
they may move before the learned court.
you pursue it ଆପଣମାନଙ୍କ ରୋଲ ବହୁତ you have to act as a friend philosopher guide କରନ୍ତୁ.
The lordship may keep the matter pending for another.
The Lord Counsel for the petitioner was had at some length. The petitioner before this court, by filing the writ application, challenges the order dated orders. Challenges the orders dated 16/8/23, 23/7/24. No. Challenges the orders dated 16/8/23 and 3/10/24. Passed in execution case number 3 of 2023, arising out of MATA case number 102 of 2014. The said execution case, as has emanated from the order in the MATA number 102 of 2014, was for execution of the amount of permanent alimony payable every month, the total outstanding remaining to be rupees 4,14,000, 4,14,000 as on from for the period from 24/6/2011 to 1/8/2023. The decree holder wife furnished the details of the drawing and disbursing officer, that is the pensionary authority of the judgment debtor, and also filed the pension payment order indicating provisional pension of rupees 60,000. The pension payment payment order indicating payment of provisional pension. The plea before the Lord Executing Court was in view of the pendency of the application of the petitioner pension holder under section 25(2) of the Hindu Marriage Act, seeking revision of the monthly maintenance. Therefore, correctly in view of then therefore the executing court should not proceed in executing the decree. The learned counsel for the petitioner is apprised of the law that the executing court cannot go behind a decree, much less can modify it to allow a lesser amount. The learned counsel for the petitioner fairly concedes that the application under section 25(2) of the Hindu Marriage Act is still pending adjudication.
That is dismissed for default.
Dismissed as per his instruction. Then Mr. Deo, learned counsel for the opposite party, submits that the 25(2) application has been dismissed for default. Stop. It is further submitted by the learned counsel for the petitioner that the petitioner shall be agreeing for an award of permanent alimony. He seeks intervention of the good offices of the learned counsel for the opposite party. In the said regard, though it is beyond the scope of the present adjudication, it can only be observed that the parties, if so advised, may agree for a permanent alimony, which shall be apprised to the learned family code, wherein the application under section 25(2) is pending. The matter shall be listed for admission in the week commencing 17/8/2026. Liberty to mention. Upon the arrive koribe, still I am not sure that whether I can direct, but I can make an observation. Upon mane raji achandi, so that kind of a thing I can do. But I think that the order has to be passed in the immediate. Upon 25 interim order by single bench. I think that is the that you have filed a writ petition. Yes, next.
38.
And on behalf of Mr. Rathore, bring some argument.
Stay achi. Adjournment. Mr. Saurabh Suman Bhuya for the petitioner. Apanaka na?
Mangu Nandi.
Mangu Nandi. Mr. Mangu Nandi for the opposite party. You belong to Rausapatna area?
My lord.
Rausapatna, the Nandi families are reporter.
Jagatpur.
Jagatpur. SR Ratha for the opposite party. The matter is listed for admission, for hearing under the heading for admission. Adjournment is sought for on behalf of the learned counsel for the opposite party on personal grounds. According to the matter shall be listed for admission in the week commencing 17/8/2026. The interim order it 23/2/2026 is reiterated. Para 7 ta repeat kar debe. Shall be adjourned beyond kar diyantu apna keto 17 kahile. Shall be adjourned beyond 24/8.
Much obliged. 39.
You are Miss Raut.
Yes, madam.
Then, 2 weeks after file is somewhere misplaced. I am for husband.
Miss Swetapadma Raut for the petitioner. Mr. Ranjit Mahanti for the opposite party. Matter is listed for hearing under the heading for admission. The learned counsel for the petition opposite party submits that his brief has been misplaced and some time may be granted to retrieve the same. According to the matter shall be listed for admission in the week commencing 17/8/2026. The learned counsel for the petitioner seeks reiteration of the interim order. Accordingly, interim order dictate 5/5/2026. Accordingly, it is directed that date ta kebe pahunchu 17/8 paragraph 8 re achi. Paragraph 8 order dated 5. Yes. Sahoo sir ji. Se Sahoo to nije aise kar dauchandi to pehla purbu.
Apologies. In item 26, I missed
26.
Yes, I missed out on mentioning the interim order.
I think I have dictated it. 26 रे order dated 11/5/26 ହେଲା paragraph 7 ଟା 26 ଟା केबे डेट करछन मिस्टर पारी
commencing 27
week commencing 27 मैटर सेल्फ जो adjourned beyond 27 7